ಇಲ್ಲಿಗೆ ಬಂತು. ಅದು ಫೈಲ್ ಕೊಂತ ತಕ್ಕೊಳ್ಳಿ. ಇದು ಮಾಡೋದು ಹೀಗೆ. ನಿಮ್ಮ ಹೆಸರಲ್ಲಿ ಏನೇನು ಯಾರು ನಾನು ಸರ್ ಇದು ಕೋರ್ಟಲ್ ನಂಬರ್ 6 ಅಲ್ವಾ ಸರ್? ನಾಗಪ್ರಸನ್ನ, ಜಸ್ಟಿಸ್ ನಾಗಪ್ರಸನ್ನ.
ಹೌದು ಸರ್.
ಹಲೋ.
ಹೌದು ಹೌದು ಸರ್.
ಓಕೆ ಸರ್, ಥ್ಯಾಂಕ್ಸ್. ಥ್ಯಾಂಕ್ ಯು.
Court officer. Court officer.
Hello, court action.
Audio video on.
Your lordship's due. I pray your lordship, since I complained to deafness, if your lordship give me opportunity for physical hearing in Dharwad, next
Which-
week I personally come and ask you, your lordship.
Which matter, sir?
Gulbarga matter.
Gulbarga, sir.
Gulbarga, yes, you're ready.
You are ready and sir.
Yes, my prayer is that your lordship, physical hearing opportunity may kindly be given to me.
When do you want?
Argue it because of my deafness.
No,
and
when do you want?
your suggestions should come from your honor.
When do you want, sir?
On Thursday, your lordship.
Thursday ಆಗಲ್ಲ, Friday.
Friday.
24
All right, sir, Friday.
24th at 2:30.
All right.
Kalburgi.
With my lords, kind permission, my lords, one matter, my lords, which is part heard, my lords, WP 13269 of 2023, my lords. My lords, the accounts of the petitioner are frozen, my lords. My
Thursday,
colleague is
23rd.
handing over.
23rd it will get listed.
I'm obliged, my lords. I'm obliged.
ಫೈಲ್ ಬರಬೇಕು 23rd ಎಲ್ಲ ನಾನು ಬೆಂಗಳೂರದೆಲ್ಲ 23rd ಮಾಡಿಸ್ತೀನಿ ಅವತ್ತು ಫೈಲ್ 23rd ಸರ್.
Most obliged, my lords.
My lord, with permission.
Yes.
My lord, serial number 5, Kalburgi bench list, my lord. I am for petitioner, my lord.
ಕಲಬುರಗಿ ಬೆಂಚಲ್ಲಿ serial number 5 ಇದೆಯಾ? 5 which list is that? RP. Yes, what do you want, madam?
My lord, in person I may be permitted to.
All right, Friday 24th.
My lord, for second.
Now call the cases. ಇದೇ ಆಗೋಗುತ್ತಾ? Next week haki, same stage, 23rd. Rajit.
For the petitioner in this case, my lords.
Yes.
My lords, I had on humble submissions for me. I had
Accused
argued
number
this
1.
matter. Sorry, my.
Yes, Rajit.
For the petitioner, my lords.
Gulbarga disconnect. Yes.
My lords, I'm for the petitioner.
Yes, sir.
Humble submission, my lords. I had argued this matter before my lordship itself in 2022.
I know.
Then it had gone for judgment. And then it was posted for orders and it remained. Orders agiyalla. ಒಂದು ವರ್ಷದಿಂದ upload ಅಂತ ಆಯ್ತು.
ಅಲ್ಲ, ವಿಡ್ರಾ ಮಾಡ್ಲಿಲ್ಲ. ವಿಡ್ರಾ ಮಾಡಿದ್ರಿ ಅಲ್ವಾ ಅದನ್ನ?
ವಿಡ್ರಾ ಮಾಡ್ಬಿಟ್ಟು ವಿತ್ ಫ್ರೆಶ್ ಫೈಲಿಂಗ್ ಮಾಡ್ಬೇಕು ಅಂತ ಪರ್ಮಿಷನ್ ತಗೊಂಡು ಧಾರವಾಡ ಬೆಂಚಲ್ಲೇ ಇದ್ರಿ. ನಾನು ಅವಾಗ ಅಲಹಾಬಾದ್ ಹೈಕೋರ್ಟ್ ಅಲ್ಲಿ ಇದೆ, ಅದಕ್ಕೆ ನಂಗೆ ಜ್ಞಾಪಕ ಇದೆ VC ಮಾಡಿದ್ದು.
ಪರವಾಗಿಲ್ಲ, ಈಗ ಮಾಡಿದಿರಲ್ಲ.
ಮಾಡಿದೀನಿ ಸ್ವಾಮಿ, ದಯವಿಟ್ಟು ಅದು ರೆಗ್ಯುಲರ್ ಬೆಂಚ್ ರಿಲೀಸ್ ಮಾಡ್ಬಿಟ್ಟು ಹಾಕಿದ್ರೆ.
ಅಲ್ಲ, ಇಟ್ ಇಸ್ ವಿಡ್ರಾ ಮಾಡಿದ್ಮೇಲೆ ನನ್ನ ಹತ್ರನೇ ಬರ್ಬೇಕದು, ನೋ ಚಾಯ್ಸ್.
ವಿಡ್ರಾ ಮಾಡ್ಬಿಟ್ಟು ನಾನು ಹಾಕ್ಬಿಟ್ಟು ಸ್ಟೇನು ಸಿಕ್ತು ಸ್ವಾಮಿ, ಜಸ್ಟಿಸ್ ಹೇಮಂತ್ ಚಂದ್ರ ಗೌಡ್ರ ಮುಂದೆ.
ಸ್ಟೇನು ಕೊಟ್ಟಿದಾರಾ?
ಕೊಟ್ಟಿದ್ದಾರೆ ಸ್ವಾಮಿ. ತಮ್ಮ ಮುಂದೆ ನಾನು ಲಾಸ್ಟ್ ಟೈಮ್ ಮುಂದೆ ಸ್ವಾಮಿ.
Which case is this then?
This is the same case, which is there is a stay already pending. There is a stay already there. Right?
Already granted, then don't.
ಹೌದು. December 23 ಅಲ್ಲಿ.
No problem. List the matter on 1st March 2023. Interim order subsisting will continue till the next date of hearing.
2025 Swami, 1st March.
Sorry, 25. Yes.
Obliged.
Yes. Next. 3rd March. Sorry. Yes. No representation way of the petitioner. List the matter on 23rd. Next.
Number 4, Suyog.
My lords, I appear for the petitioner, my lords. 505 clause 2, my lords, is the offence alleged, my lords. Earlier, my lords, I had filed, my lords, at the stage of crime stage.
Bernard AGA, additional SPP. Why is the learned advocate general waiting?
Serial number 3, my lords.
ನೀವೇ ಅಪಿಯರ್ ಆಗ್ತಿದ್ದೀರಾ?
ಏನ್ ಮಾಡೋದು?
ಏನ್ ಮಾಡೋದು?
ಅಲ್ಲ
All right, one moment. I'll come back to that. Wait. Yes, the learned additional SPP is directed to accept notice for the first respondent. For the respondents, there shall be an interim order of stay as prayed for till the next date of hearing, lest the matter on 13th in the fresh matters list.
Much obliged, my lords.
Bill number 5, Sunil Kumar.
ಅಲ್ಲ, 3 ಕೊಡಿ.
Bill number 3.
1 minute. 3 pass. ಒಂದೇ ನಿಮಿಷ.
my lord, the complaint is misconceived, my
ಬೇರೆ
lord.
ಬೇರೆಯವರಿಗೆ ಸ್ಟೇ ಕೊಟ್ಟಿದ್ದಾರಾ?
ಇಲ್ಲ, my first time it's coming, my lord.
ಓ, ಟೆಸ್ಟ್ ಡೋಸ್ ಇವ್ರದೇ. Yes, emergent notice to the heard the learned Advocate General ಏನಾ ಅಥವಾ senior counsel?
Senior advocate ಅಂತ ಹಾಕ್ಬಿಡು.
Learned senior counsel Shashkiran Shetty appearing for the petitioner. Emergent notice to the respondent returnable by the 20th of February. There shall be an interim order of stay of further proceedings till the next date of hearing.
As a lordship, the test case ಅಂತ.
ಯಾಕಂದ್ರೆ 4 accused are there. Test case ಅಂತ ಇವ್ರದ್ದು ಮಾತ್ರ ಮೂವ್ ಮಾಡಿದ್ದಾರೆ. Yes, sir.
Bill number 5, Sunil Kumar.
I think 5, 8,
and 9.
9. 5, 8 and 9.
8 and 9.
Lordship, in this matter, I'm undertaking to file an wakalat for the respond number 2, Lordship.
ಯಾರಿಗೆ sir? Which matter, sir?
The 589, Lordship.
585. Respond number 2 ಯಾರು?
De facto complaint, Lordship.
All right, no problem.
And we are also challenging the impleading order of the trial court, Lordship, but by mistake, the matter has been listed before the Honorable High Court of Karnataka at the Bangalore bench, Lordship. At type number 166.
I think he's appearing in some other matter, maybe.
Which matter are you talking of, sir?
Gulbarga bench and Karnataka.
No, Lordship, the same matter.
Which matter?
ಏನಾಗಿದೆ ಅಂತಂದ್ರೆ
It is special court matter, sir. How can it be listed before the Bangalore bench?
ಆಗಿರೋದು.
By mistake, it was listed, Lordship. It is listed.
By mistake?
Yes, Lordship.
Then you rectify the mistake to get it here. Yes.
Yes, Lordship. We'll make a submission here, Lordship.
Make a submission.
And I'm undertaking to file an wakalat for R2, Lordship.
No
in
problem.
589.
Petitioners are here.
Yes.
I'm hearing them.
Please,
Yes,
Lordship.
next.
Please, Lordship.
Yes, sir.
What happened? He's appearing.
An offshoot of my order?
Yes.
Yes.
ಇದರಲ್ಲಿ when my lord disposed of the earlier petition by allowing the petition and setting at not my lord the order which came to be passed by the learned trial judge. My lord, this Malava, the first informant in the case, who is none other than the wife of the deceased, and who in fact is the first informant in the case, and who comes squarely within the meaning of the definition of the word victim as defined under section 2WA of the CRPC. Despite the fact that she was made a party respondent, she was not even notified in the earlier petition. That is number
Respondent.
Haudu. Aita. That is number 1. Number 2, my lord, when A1 makes an application invoking the jurisdiction of the court under section 306 before the trial court, she would appear before the trial court, file a statement of objections, opposing the application on the score that he is the principal accused in the case. I am the aggrieved. I am the victim. I am the first informant in the case. I am the widow. But on the merits, he is the principal accused in the case. His complicity is more. But you can't grant him the pardon was the statement of objections which came to be filed by the first informant in the case before the trial court.
First informant herself objected to granting of pardon.
Yes. Number 2. Well, the learned judge probably, anyway, we are not there for her. Some other counsel is there. Probably, my lord, you would reject her application also solely on the ground that you can't maintain the application. She can't maintain the application. No one else can maintain the application. That is a different issue. Being agreed with the order which came to be passed by the trial court, Malava has also filed a criminal petition. That is what
166 ಅಲ್ಲಿ ಹೋಗಿದೆ ಅಂತ ಹೇಳ್ತಾರೆ.
ಅಲ್ಲಿ ಏನಾಗಿದೆ ಅಂತಂದ್ರೆ ರಾಂಗ್ ಸಬ್ಮಿಷನ್ಸ್ ಇನ್ಕರೆಕ್ಟ್ ಅದೆಲ್ಲ ಏನಲ್ಲ. The registry has listed the matter before Honorable Justice Krishna Kumar.
ಅದೇ that's what that was.
ಇವತ್ತೇ ಇದೆ ಅದು.
ಅಲ್ಲ ಅಲ್ಲಿ let them make the submission there. ನಾವು ಇಲ್ಲಿ ಏನ್ ಹೇಳ್ಬೇಕು ಹೇಳ್ಬಿಡಿ.
ಅಲ್ಲಲ್ಲ, ಅದು ಇದ್ರ ಜೊತೆಗೆ ಬರ್ಬೇಕು ಅಂತ ಕಾಣುತ್ತೆ ಅವಾಗ. Otherwise what happens?
ಅದನ್ನ he has to pass an order.
ಹೌದು ಮಾಡ್ಬೇಕು.
Because the lordship.
ಅಲ್ಲ, ನಾವು ಇವತ್ತು ರೆಡಿ.
Lordship
Let
is
us not
Mr.
be
Kumar being
misunderstood that we are not ready, my lord.
pass an order. I
No,
cannot.
we are not, let it not be misunderstood that we are not ready to argue the matter. We are certainly ready to argue the matter. But ಏನಾಗುತ್ತೆ?
ಅಲ್ಲಿ ಕೌನ್ಸಿಲ್ ಅವ್ರ ಹೆಸರು
Yes, Lordship. Praveen Kumar, Lordship.
Praveen Kumar.
Yes,
You
Lordship.
will have to make a mention there
Yes,
when the
Lordship.
matter is called. Or if the matter does not reach, make a mention and get it, it pertains to special court anta.
Please, Lordship.
All right.
Yes, Lordship. Lordship.
ನೀವು ಹೇಳೋದು ಹೇಳಿ.
ಅಲ್ಲಲ್ಲ,
ಇಲ್ಲ ಅದು ಬಂದ್ಮೇಲೆ ಮಾಡ್ತೀರಾ?
ಅದು ಐ ಥಿಂಕ್ ಇದು ಫಿಟ್ನೆಸ್ ಆಫ್ ಥಿಂಗ್ಸ್ ಅಂಡ್ ಇನ್ ಫೇರ್ನೆಸ್, my
ಅದು
lord.
ಬರ್ಲಿಲ್ಲ ಅಂದ್ರೆ
ಬರ್ಲೇಬೇಕಲ್ಲ. If not today, tomorrow it has got to come.
so next date available is 23rd.
ಅಲ್ಲ, if my lord is sitting in Bangalore.
ಅವಾಗ ತಗೊಳ್ಳ.
ಅಲ್ಲ, ಯಾವಾಗ? ಅಲ್ಲ, ನಮಗೇನಿಲ್ಲ, ಬರ್ತೀವಿ, ನಮಗೇನು ತೊಂದರೆ ಇಲ್ಲ.
ಇಲ್ಲ I'll take it on 23rd.
ಮತ್ತೆ
ಬೇಕು. ಎಸ್ ಪ್ರಸನ್ನ ಕುಮಾರ್ ಸರ್. 23rd ದೂರ ಆಗತ್ತಾ?
You will first not please to not fixed not time for conclusion of the trial.
ಅದನ್ನ ಹೇಳ್ತೀನಿ, ಅದಕ್ಕೂ ಹೇಳ್ತೀನಿ.
ಮೈ ಆರ್ಡರ್ ಏನಿದೆ?
Of course.
ಎಕ್ಸ್ಟೆಂಡ್ ಮಾಡ್ಬೋದು, ಅದಕ್ಕೆ ತೊಂದರೆ ಇಲ್ಲ.
Extend ಮಾಡ್ಬೋದು.
Really, I don't know whether it was, I think we erred or we failed in bringing your lordship's notice, my lord, the constitution bench of the Supreme Court, when my lord fixed the time of 2 months. The constitution bench has said it can't be done.
In 2WA. Constitution 2WA.
Really? No, my lord, what happened was it was reserved for orders.
No, true, but I did not even see that
Constitution
complaint was there.
Constitution bench has said it can't be fixed.
No, that is true. That I am
And
aware.
then subsequent, following the constitution bench judgment,
No, that I am aware.
Justice Oka, my lord, has.
No, I am completely aware that
Can't be.
complainant has to be heard.
ಅದಕ್ಕೆ
But in a case of granting pardon.
ಅದಲ್ಲ. What I am submitting is your lordship has fixed the time limit of 2 months. ಅಲ್ಲ, ಇವ್ರು ಹೇಳಿದ್ರಲ್ಲ, ಅದಕ್ಕೋಸ್ಕರ ಹೇಳಿದೆ ಅಷ್ಟೇ ನಾನು.
Conclusion of the trial I have granted, I will extend it. That's
ಅಷ್ಟೇ,
not a
ಅಷ್ಟೇ.
problem.
But with or without, it is coming to an end sometime during the
February
7th, first week of February itself. ಬೇಕಾದ್ರೆ ಈಗಲೇ ಇದರಲ್ಲೇ
ಅಲ್ಲ 23rd ಆಗುತ್ತೆ.
23rd ಆಗುತ್ತೆ. ಇದೆ ಕ್ರಾಸ್ ಎಕ್ಸಾಮಿನೇಷನ್ ಏನು ಆಗ್ತಾ ಇದ್ದಂಗೆ ಕಾಣ್ತಾ ಇದೆ.
And the learned judge has
Let
taken
that
1
not
month for
happen till
disposal of this
23rd.
application itself.
No, 23rd orge, let the court hold its, let that petition also come and we will do it.
ಬೇಕಾದ್ರೆ ಒಂದು ಶುರು ಮಾಡೋಣ ಅಂದ್ರೆ ಮಾಡ್ಬೋಣ ಒಂದಿಷ್ಟು.
ಈ ಶುರು ಮಾಡಿದ್ರೆ ಎಂಡ್ ಮಾಡ್ಬೇಕು. No problem. Expression is accepted.
ಅದು ಏನಾಯ್ತು ಅಂತಂದ್ರೆ, ಅಲ್ಲ, the learned
ಯಾಕೆ?
ಅಲ್ಲಿ ಏನಾಗಿದೆ ಅಂತಂದ್ರೆ,
ಅದಕ್ಕೆ ನೆಕ್ಸ್ಟ್ ಥರ್ಸ್ಡೇ.
ಅಲ್ಲ, ಅದ್ರಲ್ಲಿ ಏನಾಗಿದೆ, ಸ್ಪೆಷಲ್ ಕೋರ್ಟ್ ಅಲ್ಲಿ your lordship direction in the earlier petition is
I will accept it.
the trial to conclude within a period of 2 months. Trial may not is framing of charges and recording of evidence. That is what the constitution bench has said it. ಇಲ್ಲಿ ಏನಾಗುತ್ತೆ, for the disposal of this application itself, the learned trial judge has taken 1 month.
No, that I will extend. Not a problem.
Probably you
Now what is the order impugned?
in brief ಬೇಕಾದ್ರೆ ಒಂದು ಸ್ವಲ್ಪ ಹೇಳ್ತೀನಿ, so that
ಅಲ್ಲ, ಈಗ after my order, what
Yes.
happened?
after your lordship's order, your lordship's order consists of 3 things. Number 1, there is no legal impediment for the accused to maintain a second or a third application in the event of there being in a change in circumstance. That is how the Supreme Court has said, and your lordship has also observed in the very order itself. Again, what the learned judge would say is, the trial judge would say is, the only change in circumstance that would come into play subsequent to the disposal of the second application by an order which your lordship can be passed is, that is put into constant fear. That is the change in circumstance. That can't.
That was my observation as well in one line. That can perhaps become a change because constant fear is always a circumstance that goes on.
No, constant fear not for the witness, for the accused. He is my companion accused. He is the first accused. He is the first accused. Why should I threaten him? He is not a witness for the prosecution.
Why should you threaten? He is turning approver anta you may threaten him.
Allah, no. His application is right from the inception of the case, he is being threatened. approver ಹಾಗೆ application ಹಾಕಿದ್ಮೇಲೆ ಅದು ಬೇರೆ ವಿಚಾರ ನೋಡೋಣ. ಆಮೇಲೆ that may not be a ground. That's certainly.
That we'll consider.
That may. ಒಂದು
ಬರಲಿ ಅಂತ ಮಾಡೋಣ.
Next. Oh,
ಅದೊಂದು. Next, another serious and an important legal issue which we have raised, my lord, while placing reliance on the judgments of the Supreme
but
Court.
this is not challenged by anybody.
No,
This
it is
all.
not. No one has challenged. It has reached finality. My lord, in brief, na ಹೇಳ್ತೀನಿ ಅಷ್ಟೇ. ಇನ್ನೇನಿಲ್ಲ. In depth, then we will argue the matter.
All right.
My lord, the next is important, serious legal issue which we are raised is, when an accused would go and make an application under section 306. Illi 306 is not applicable. It is only under section 307, my lord. The court
307.
doesn't matter, my lord, merely because wrong quoting of a provision does not
Will
take
not,
away the
vitiate.
jurisdiction of the court in the event of the court being clothed with the power or the authority or the jurisdiction to pass an order. Illi, it involves two things. Firstly, my lord, he should be given, but he is my companion accused. He is an accused in the criminal case.
Given.
His status needs to be elevated from that of an accused to that of an approver, number one. And
Transposed.
thereafter, my lord, he has got to be transported as a witness for the prosecution. That is why, my lord, his hierarchy or the rank goes up. No sooner an order is passed, my lord, granting him or accepting him as an approver and granting him the pardon and elevating his status as a witness, my lord, how the Supreme Court has said is, he has got to be given the pardon. Number one, that pardon he has got to accept it. Without which, my lord, he can't pass an order. That is the important and a serious legal issue. That is how, my lord, the Supreme Court has said. But why he has to be given a pardon and he has got to accept the pardon is so that, my lord, ultimately, when he again turns hostile after being treated as an approver and elevating his status, then, my lord, the procedure that is mandated under section 308 has got to be followed. My lord, if he does not accept the pardon, my lord, you can't invoke.
He will have to be brought back as an accused under
Yes,
319.
you can't do it. If you don't give him the pardon, if he doesn't accept it, my lord, he can't do it under section 308. ಇಲ್ಲ ಅದು ಮಾಡೇ ಇಲ್ಲ ಅದನ್ನ. ಅಲ್ಲ another legal issue ನಾನು ಹೇಳ್ತಾ ಇರೋದು.
All right, 23rd here ಮಾಡೋಣ. ಅದು ಬಂದ್ಬಿಡ್ಲಿ.
ಬರ್ರಿ.
ಶ್ಯಾಮ್ ಸುಂದರ್ ಸರ್ ಯಾರಿಗೆ? Same order.
Same or different accused.
Now it is allowed, is it?
Please.
Pardon is allowed.
Please.
Sir, Lord, he has been already examined.
Already examined. ಓ ನೀವೇ?
ಆ ಕಡೆ ಇದ್ರು ಈ ಕಡೆ ಬಂದಿದ್ದಾರೆ.
ಇವ್ರು ಯಾಕೆ ಈ ಕಡೆ ನಿಂತಿದ್ದಾರೆ ಅಂತ ನೋಡ್ತಾ ಇದ್ದೀನಿ.
The matter.
Correct. There's an interim order, right?
Interim order.
ಎಲ್ಲಾರನ್ನ ಒಟ್ಟಿಗೆ
ಆಮೇಲೆ
By the vacation bench.
another
ಎಲ್ಲಾರನ್ನ ಒಟ್ಟಿಗೆ ಕ್ರಾಸ್ ಎಕ್ಸಾಮಿನೇಷನ್ ಮಾಡ್ತೀನಿ.
another legal issue is another serious legal issue is 164 statement, he can't record it.
That is over.
That is the, no. He sends the.
What is, no, ಅದೆಲ್ಲ ಆಯ್ತು. He sent.
No, ಅದೇ he refers to 164 statement. In his order, my lord, which came to be passed, he would refer to 164. Which has virtually become. May I request your lordship to kindly turn to. ಒಂದೊಂದಾಗಿ ತೋರಿಸ್ತೀನಿ ಬೇಕಾದ್ರೆ ಏನು ಅಂತ ಅಂದ್ಬಿಟ್ಟು. Kindly go to page 89, my lord, for a second.
ಅಲ್ಲ 89 he says.
ಅಲ್ಲಲ್ಲ.
It was squashed by this
ಅಲ್ಲಿಂದ
court.
ಶುರು ಆಗುತ್ತೆ. Kindly go to page 94. ಅಲ್ಲಿಂದ ಶುರು ಆಗುತ್ತೆ. 5th line. Well, not that we are building castles in air. Serious legal issues. At the cost of repetition, it is noticed that at the time of filing of the second application, also no reasons were assigned But the reasons and the disclosures which he was intending to make was disclosed in his statement record under section 164 CRPC. Under the circumstances of the matter. Tappa. My lord, it has become a dash. He could not have referred to 164 statement at all. He refers to it for the purpose of passing of the order, accepting him as an approver,
Why is this?
granting him pardon,
Independent,
recording evidence.
independent evidence issue.
No, what he has said, no, your lordship, look, end not mailing the, at the cost of reputation, it is noticed, at the time of filing second application, what transferred and the bardidarashte. What is recorded is, what happened at the time of filing the second application, not the finding not on the third application.
Howda? Kindly read the next sentence, my lord. When the aforesaid aspects are considered with the present application, it would indicate that the same will amount to change of circumstance. Okay?
The manner in which human mind reacts to the situation.
Allah,
different circum-
when the aforesaid aspects,
Ah,
Transferred earlier, very bad.
howda?
ನಿಮಗೇನ್ ಥ್ರೆಟ್?
Alala, next sentence, when the aforesaid aspects are considered with the present application, it would indicate that same will amount to change in circumstance.
Page 1 in the ಓದಬೇಕು.
ಓದೋಣ?
Not the whole line.
ನಾನಿಲ್ಲ ಅಂತ ಹೇಳಿಲ್ಲ. ಅಲ್ಲ, ನಾನು bird's eye view of what we have urged, because your lordship has said, while disposing of the earlier petition, the accused is indeed entitled to raise the legal issues that are involved in the case. That is how my lord has said it. ನಾನು ಇನ್ನೂ ಒಂದು 2-3 ಬೇಕಾದ್ರೆ ತೋರಿಸ್ತೀನಿ legal issues.
ಲಾ ಲೆಕ್ಸಿಕನ್ ಏನೇನು ರೆಫರ್ ಮಾಡಿದ್ದಾರೆ? 307 ಅಲ್ಲಿ ಪಾರ್ಡನ್ ಕೊಟ್ಟಿದ್ದಾರೆ and 307.
ಹೌದು. ಅಲ್ಲ, ಎಲ್ಲಿದೆ?
Your examined
Of pardon. What the Supreme Court has said is, it gets concluded only if you accept the pardon. May I invite my lord's attention to
by the very court which grants pardon.
which granted the pardon. I was about to say that. Number of legal issues.
Pardon. Yes.
ಈ ಸಾರಿ we will put an end to it, my lord, before this court. ಯಾಕಂದ್ರೆ ಮತ್ತೆ ಪುನಃ ರಿಮಾಂಡ್ ಅಂತಂದ್ರೆ, because the accused would certainly take leave.
No remand. We will decide it here.
ಅಲ್ಲಲ್ಲ, ಇದ್ರಲ್ಲಿ ಏನಾಗಿದೆ ಅಂತಂದ್ರೆ, he is taking advantage of the observation which came to be made by this court, that no one can restrict him from making application after application. No. My lord,
We'll see. We'll answer it.
please, I'm sorry.
ನಾಗೇಂದ್ರ ನಾಯಕ್ ಏನೋ ಅಂದ್ರಲ್ಲ.
ಲಾಸ್ಟ್ ಟೈಮ್ ತಾವು ರಿಮೈಂಡ್ ಮಾಡಿಲ್ಲ, ಎಲ್ಲ ಪ್ರೆಷರ್.
ಅದೇ
ವರ್ಚುವಲಿ ಏನದು?
ಅಲ್ಲ ನೀಲ್ ಆರ್ಗ್ಯದ.
ಯಾರು ಇಲ್ಲ ಅಂದವ್ರು? ಅಲ್ಲ, ಇಲ್ಲ ಅಂದವ್ರು ಯಾರು? ಈಗಲೇ ರೆಡಿ.
ಅವರು ಕಾನ್ಸ್ಟೆಂಟ್ ಫಿಯರ್ ಇದ್ದಾರೆ. ಕಾನ್ಸ್ಟೆಂಟ್ ಫಿಯರ್ ಇಂದ ಅವ್ರ ಇನ್ಸ್ಟೆಂಟ್ ಅಪ್ಲಿಕೇಶನ್ ಆಗ ತಕ್ಷಣ.
ಅಲ್ಲ, ಅವ್ರ ಅರ್ಲಿಯರ್ ಅಪ್ಲಿಕೇಶನ್ ತೋರ್ಸೋಣ. ಎವ್ರಿಥಿಂಗ್ ಈಸ್ ಇನ್ ಆರ್ಡರ್, ವಾಟ್ ಎವರ್ ದಿ ಕೋರ್ಟ್ ಹಸ್ ಡನ್ ಅರ್ಲಿಯರ್. ಅವಾಗ ಫಸ್ಟ್ ಧಾರವಾಡ ಕೋರ್ಟ್ ಅಲ್ಲಿ ಆಯ್ತಲ್ಲ, ಅವಾಗಿಂದು ಅವ್ರ ಅಪ್ಲಿಕೇಶನ್ ಹಾಕಿದ್ದಾರೆ. ಏನಂತ? ಪರ್ಫೆಕ್ಟ್ ಆಗಿದೆ, ಎಲ್ಲಾನು ಚೆನ್ನಾಗಿ ಎವಿಡೆನ್ಸ್ ಕಲೆಕ್ಟ್ ಮಾಡಿದ್ದಾರೆ ಅಂತ ಹಾಕಿದ್ದಾರೆ ಅವರು. And your lordship has confirmed that. Your lordship's order. Your lordship may recall.
Yes,
Your lordship's memory. That is what Mr. Nagendra Naik's client has said before this court.
De facto complainant is not supporting the application.
Well, what she wants is, because we were also served with the copy, what she wants is that he should be punished. He is the principal accused. For the purpose of grant of pardon, for the purpose of acceptance of an application to treat him as an approver, what needs to be seen is the barest minimum culpability. Well, if he is the principal accused,
The complainant, she has turned hostile.
She has turned hostile. Complainant herself has turned hostile. ಮತ್ತೆ ಯಾವ್ದ್ರಲ್ಲಿ ಏನ್ ಮಾಡ್ತಾ ಇದೆ? Yes.
She was hostile based of the approver only.
It's a CBI case.
not to her case.
Initially.
ಅಲ್ಲ, case of the CBI, correct?
ಹೌದು, ಅಲ್ಲ, her case is that A1 has mercilessly assaulted her husband ಅಂತ. CBI case is no, he did not do anything ಅಂತ.
CBI case second phase. First phase is
no.
state case ಅಲ್ಲಿ she was turned.
We'll see. Yes. Now the question is only with regard to pardon,
ಅಷ್ಟೇ ಅಷ್ಟೇ.
not the whole issue.
Not the whole issue.
My lord,
Yeah, all right.
I may be, I
We'll
may
go
be
into the
permitted to
fundamental.
delete, my lord, R3. I may be permitted to delete R3.
R3 ಯಾರು?
Approver. ಬೇಕಾಗಿಲ್ಲ, ನನಗೆ ಬೇಕಾಗಿಲ್ಲ. I am not asking.
No.
Instead, I have.
Pursuant to order of the court.
Order ಮಾಡ್ಬಿಟ್ಟು.
Pursuant to order of the
ನನಗೆ
court.
ತಕರಾರಿಲ್ಲ.
Why approver should be?
ಇಲ್ಲ ಹೇಳ್ತೀನಿ, ನಾನು ಹೇಳ್ತೀನಿ, ಅವ್ರು ಅದ್ರ ಮೇಲೆ ಆರ್ಗ್ಯೂ ಮಾಡಂಗಿದ್ರೆ ಮಾಡ್ಲಿ, ನಾನು ಮಾಡ್ತೀನಿ. Why I am necessary party? My lord, in the previous round of litigation. My lord,
No, that's what I was surprised on the last occasion. When you said approver has to be heard, what is going to divulge? What is this?
whether the pardoning is right or because I am the beneficiary of the law. My rights are affected.
Allah, this, no, hearing the, all right, anyway, you are made a party now.
ವಿಚಾರ ಗೊತ್ತಿರ್ಲಿಕ್ಕಿಲ್ಲ, ನಾನು ಏನ್ ವಿಚಾರ ಇದೆ ಅಂತ ನಾನು ಅವ್ರಿಗೆ ಸ್ವಲ್ಪ ಹೇಳ್ತೀನಿ.
ಅವ್ರ ಪರವಾಗಿ ಹೇಳ್ತಾ ಇದ್ದಾರೆ.
ಅಲ್ಲ, ಅವ್ರಿಗೆ ಗೊತ್ತಿಲ್ವಂತೆ, ನಾನು ಹೇಳ್ತೀನಿ, ಕೇಳ್ಕೊಳ್ಳಿ.
That is what last time I asked. Why the person who has been granted pardon should be heard in a case where the accused are challenging the act of grant of pardon.
My lord, the principles of necessary party.
ಯಾವ necessary party natural justice ಇಲ್ಲ ಸರ್ ಇಲ್ಲಿ.
ಅಲ್ಲ, ನಾನು ತೋರಿಸ್ತೀನಿ, why I am necessary party.
All right.
Already I am added as.
Why did you?
Now you are added. I am not saying. Delete ಮಾಡೋದೇನ್ ಬೇಡ ಇರ್ಲಿ.
ಅಲ್ಲ, ಈಗ ಅವ್ರ ಪಿಟಿಷನ್ ಅಲ್ಲಿ ಅವರೇ ಪಾರ್ಟಿ ಮಾಡಿದ್ದಾರೆ.
ಅವರೇ ಮಾಡಿದ್ದಾರೆ.
ಇನ್ನೊಂದರಲ್ಲಿ ಕೋರ್ಟ್ ಡೈರೆಕ್ಷನ್.
ಇರ್ಲಿ, ಏನ್ ತೊಂದರೆ ಇಲ್ಲ.
Because court direction ಒಂದರಲ್ಲಿದೆ. ಇರ್ಲಿ, ತೊಂದರೆ ಇಲ್ಲ.
ಇರ್ಲಿ, ಏನ್ ತೊಂದರೆ ಇಲ್ಲ.
Heard the learned senior counsel, senior counsel C.V. Nagesh, learned senior counsel Sandesh Chowta, learned senior counsel M.S. Shyam Sundar. Hierarchy correct.
Why did you make him a party?
ಅದಕ್ಕೆ. So appearing for the petitioners in all these cases. And the learned counsel P. Prasanna Kumar representing the CBI, counsel Shri R. Nagendra Naik representing the accused number 1, now the approver. Now who is said to be the approver. Respondent number approver, Basavaraj Shivappa Muttigi. Adu different accused, different respondents irtare, same name ಆಗ್ಬಿಡಿ. Nagendra Naik. The learned senior counsel Shri C.V. Nagesh takes this court through. ಅಲ್ಲಿ ಇನ್ನೊಂದು ಹಾಕ್ಬಿಡಿ. The learned counsel Praveen Kumar representing the de facto complainant submits that he has also filed a criminal petition, writ petition challenging this very order, and the registry has erroneously listed the matter before the principal bench today. Therefore, it is his submission that he would make as he would bring it to the notice of the concerned of the court before which the matter is listed, that the matter pertains to the special court and has to be tagged along with these matters. The submission is placed on record. The learned senior counsel Shri C.V. Nagesh takes this court through the order impugned, which is an offshoot of an order that is passed by this court on 4/12/2024. The learned senior counsel would submit that the nuances of grant of pardon in law has been completely ignored by the concerned court. The learned senior counsel Sandesh Chowta would submit that 3 aspects for grant of pardon is given a go by the concerned court. He would submit that in a case of grant of pardon, there should be an order of pardon. The order of pardon should be accepted by the person who sought pardon. And ಮೂರನೇದೇನು? Then pardon. And the examination of the person who is granted pardon as examination in chief. The submissions made by the learned counsel, senior counsel M.S. Shyam Sundar would tow the submissions of both the learned senior counsel. A perusal at the order does not indicate the compliance as is projected by the petitioners. Therefore, it is for the respondent CBI or the Counsel Nagendra Naik, representing the person who has now been granted pardon, to steer clear the law qua the facts by the next date of hearing. The next para. The learned senior counsel for the petitioner submits that the court is proceeding with the matter in the light of the time frame fixed by this court in the earlier petition, which was to conclude the trial within 8 weeks from the date of receipt of the copy of the said order. Since the issue with regard to grant of pardon is still to be decided in its legal sense, I deem it appropriate for the present to stall further proceedings before the concerned court till the next date of hearing, and the outer limit for conclusion would be decided on the next date. Tag all these petitions. Praveen Kumar, adal mention Madi.
We'll do it, Lordship.
Yes. Then there should not be conflicting orders. Yes.
Please, Lordship.
Yes.
Great.
23rd, 2:30 ke beka hai? No, 23rd is full day Bangalore bench. We'll see. Yes, anytime. Illa, 23rd. No, Thursday I've exclusively told the president here that we'll take special court and Bangalore matters. All other days, no Bangalore matter. No, that is why. ಅದಕ್ಕೆ ಇವತ್ತು I have finished that list. Dharwad list ಮುಗಿಸಿ ತಗೊಂಡಿದ್ದೀನಿ. 23rd, 2:30.
Great, Lordship.
Bill number 6, Sirajuddin Ahmed.
Praveen Kumar, idರಲ್ಲಿ you will take notice to the
R2, Lordship.
complainant.
Yes, Lordship.
Counsel Praveen Kumar accepts notice for the second respondent, de facto complainant, Mallava, in all these cases. Yes.
Great, Lordship.
Yes. Registry to print the name of swords.
7, Kartik Venkatesh.
Apply for the petitioner, my lord.
For respondent, my lord.
Apply for the petitioner.
We'll do it. It doesn't work with that speed. Limitations, yes. ಬೇರೆ ಯಾವ್ದು ಕೇಸ್ ಇಲ್ವಾ? ಅಲ್ಲ ಅದಾಯ್ತು, ನಿಮ್ದು ಕೇಳಿದ್ದ. Next.
Apply for the petitioner, my lord.
ಯಾವ್ದು? ಸಿರಾಜುದ್ದೀನ್.
Serial number 7, my lord.
7, Karthik.
Yes, my lord.
Post immediately after service of notice upon the second respondent. Interim order subsisting will continue till the next date of hearing. Yes, next.
My lord, ಇದರಲ್ಲಿ 7 ಅಲ್ಲಿ ಸ್ವಾಮಿ. Hello, my lord.
ಇದ್ದೀರಲ್ಲ ನೀವು already.
Yes, my lord.
ಮತ್ತೆ ಯಾಕೆ why is this Shara? Yes, sir. What's the matter?
Let me turn to page number 88, my lord.
Oh, last time I had indicated promissory note ಅಲ್ಲಿ ಏನು ಇಲ್ಲ. No, ಇದು. No case. Yes, sir.
Let me turn to page number 88, my lord. Once.
Yes, sir.
My lord, I have the explanation of the entire note, which includes the signatures of the petitioner also, my lord.
No.
My lord, may see page number 88, my lord.
No fault can be found with the order of the concerned court. Yes.
My lord, one submission. My lord, I have, my lord, from the inception of trial, my lord, my contention has been that the entire document is a forged document. If this opportunity is not given, my lord, I will not be able to rebut my presumption. My lord, I indeed made this application on 25/7/2023, my lord.
Yes.
I also filed a memo along with the depositions, my lord. Lord, may please take that one.
Yes, sir.
My lord, in this matter, yes, the accused has admitted this thing, the signature on the check, my lord. He's disputing the signature on this undemand, my lord.
Anything else, sir?
My lord, my humble submission is, my lord, I have sought for the examination of the entire note, my lord. The signature does not belong to the petitioner, my lord. My lord, one promissory note is seen. One signature is horizontal, another is vertical, my lord.
ಈಗ you have admitted your signature on the check?
Yes, my lord, yes, but not on the promissory note, my lord. Right from the inception of the trial, I have not admitted, but that is my signature on the promissory note, my lord.
That liberty you will have before the court. Then it is only a 45 order. Yes. Anything else?
My lord, one submission, my lord. One submission, my lord. My lord, at least my lord may give me liberty to file an because this is the
Liberty to what, sir?
Opportunity where I can rebut the.
What liberty?
Manoj, I have sought for forensic examination of the entire pronote, Manoj.
No, what liberty you want?
Manoj, to file a fresh application, Manoj.
My lord, it is the matter pertains to year 2019, my lord.
Yes.
Manoj,
You then withdraw this petition. You avail of any remedy that is available in law, if available in.
Manoj, one solution, if this is sent, Manoj, respondent will not be put any jeopardize, Manoj. It is simple for forensic examination, Manoj.
No, not every case should be sent for forensic examination.
Manoj, I have disputed the signature right from the inception.
That's not the purport of 45 or 73. Yes.
Manoj, I have fought for the entire document, Manoj. It is forged document. My lords may see my application also. I have also mentioned that the signatures are also forged, Manoj.
No, sir. Yes.
Manoj, one humble submission, Manoj. It may be sent, Manoj. Otherwise, I'll lose my opportunity to rebut.
No, sir. Nothing. Yes.
Manoj, produce certain depositions that may be looked at, Manoj.
I will vacate the interim order. You produce whatever you want. Yes.
No, Manoj, it's a simple application.
No, sir.
Examination.
No.
Sir,
if you have taken an interim order, you should be ready for the other way also. Yes.
Manoj, just a few submissions.
The case of 2017 is pending for a long time. Now I am not going to 18.
Manoj,
yes.
Manoj, my application may be seen. My prayer is, Manoj, to send it for forensic exam. Manoj, signatures
I know,
are not.
sir, that is section 45. It is rejected. There is no warrant of interference with the rejection. Yes. That's
Manoj, it is written 73, Manoj. One submission, Manoj. One humble submission.
Yes.
Manoj, one submission, Manoj. Please,
Yes,
Manoj.
sir.
I humbly pray, Manoj. Manoj, I see page number 88 for one moment, Manoj. One moment.
88 I've seen, sir. Yes.
Manoj, I see page number 34, Manoj, for a moment. 34, Manoj. Manoj, this promissory note is only produced after, Manoj, the complainant does not come for cross-examination, Manoj. It is not produced at the initial.
All that you contend before the court, sir. This is only concerning whether it should be sent for forensic examination or not, according to me, need not. Yes.
Manoj, it does not. Manoj, signature does not belong to me. At least liberty may be given, Manoj. Liberty may be given. That is all I pray.
You withdraw this petition, we'll give you whatever liberty you have in law, you take it.
Manoj, at least a fresh application. Manoj, this court is empowered with wide powers, Manoj. At least to file application before the
learned counsel for the petitioner, after arguing the matter at length, would seek leave of this court to withdraw the petition and avail of the remedy as available in law before the concerned court. The petition is disposed as withdrawn, reserving liberty to the petitioner to avail of such remedy as is available in law. Yes, next.
Bill number 8, Lakshmikant ji.
CBI 8 ಇದು ಆಯ್ತಲ್ಲ 8 ಅದೇನೆ ಮೇಡಮ್ 5, 8 and 9 ಮೂರು ಅದೇ.
Cell number 10, admission matter, Girish Kumar.
For the respondent.
Yes, sir.
(482) petition.
482 petition. Yes.
Oh.
Yes. ಅದು ಮಾಡ್ತೀರಾ ಫಸ್ಟ್? ಅಲ್ಲ ಯಡಿಯೂರಪ್ಪ ಮುಗಿಸ್ಕೊಳ್ಳೋಣ ಫಸ್ಟ್. ಆಲ್ ರೈಟ್. Just I'll run through the list. After that, I'll take this. Yes, 11.
Cell number 11, Vijay Kumar Prakash.
List on 23rd. Yes, Prasanna Kumar sir. ಯಾವುದು? Didn't pass.
Cell number 12.
ಪ್ರಸನ್ನ ಕುಮಾರ್ ಇಲ್ಲ ಇದ್ರಲ್ಲ.
IMA matters. ಇಲ್ಲ ಪೊಲೀಸ್ ಆಫೀಸರ್ ಡಿಸ್ಚಾರ್ಜ್ ಆಗಿದೆ.
ಗೊತ್ತಾಯ್ತು. ಏನ್ ಡಿಸ್ಚಾರ್ಜ್ ಆರ್ಡರ್ ಮೇಲೆ?
Prime accused not was discharged. ಅದು SLP ಏನೋ ಆರ್ಡರ್ಸ್ ಗೆ ಹೋಗಿತ್ತು ಮತ್ತೆ ಏನೋ ವಾಪಸ್ ಬಂದಿದೆ. It was not reserved for orders after ಅಲ್ಲ ಇರಲಿ. Not in the Supreme Court.
Supreme Court reserve
My lord, I
There was
appear
one matter
for
not which was reserved, not say. Order not
no,
was
no,
not
my
passed.
lords. In fact,
Subsequently,
none of the
my lord,
matters are reserved in the
there
Supreme
was change
Court.
in the bench.
Supreme Court reserve ಆಗಿದೆ.
ಇಲ್ಲ ಸ್ವಾಮಿ, ಯಾವುದು ರಿಸರ್ವ್ ಆಗಿಲ್ಲ. Nothing is reserved in the Supreme Court.
Bench ಬದಲಾವಣೆ ಆಯ್ತು. Not one of the bench judge may not got retired.
Discharge order I will not enter.
But your lord, my only request is not your lord, me keep this pending for 4 weeks.
My lords, the ground on which the discharge has been granted is completely different on the aspects on which the matters are pending before the Honorable Supreme Court, my lords. In fact,
What is pending before the Supreme Court?
Not
my lords, two other IPS officers had preferred 482 petitions, my lords. One of the orders was allowed by
police officials, not your lordship's order, the other one.
No, even my lord's order is also before the Honorable Supreme Court. No stay has been granted. No stay has been granted, my lords.
I'm not on 23rd, my lord,
Discharge I will not interfere.
23rd, my lord, you have to keep it, not I'll make my
No ground to interfere discharge.
On 23rd, my lord, may I go.
Finally,
Please.
list the matter on 23rd at the request of Learned Counsel for the CBI P. Prasanna Kumar. ಅವತ್ತು ನೀವ್ ಯಾರಿಗನಾಗಿದ್ನ?
One of the
ಒಂದಕ್ಕೆ ಸ್ವರೂಪ ಅನ್ನೋದು ಒಂದು ಇವ್ರ.
Please.
13.
My lord, it is the same matter, my lords. I appear in 13.
12 and 13 same, both 23rd.
This 21, ED ಒಂದಿದೆ, ಅದನ್ನು 23rd ಮಾಡಿ.
ಯಾವ್ದು ಇಡಿದು?
ED, not this Swati Jaiswal. Summons not issued by CD.
My lords, I appear for petitioner.
Wait, I'll post it on that date.
Please.
My lords, interim order are there in this.
That will continue, sir. Interim orders will continue.
Please.
My lords, so.
Number 14, Vinayak Vaman Rao Kulkarni.
I appear for the petition in 14 lords.
ಇದು ಅಲ್ಲೇ ಬರ್ಲಿ.
Great. 23.
On
23rd, my lord.
List on 23rd. Jagdish sir, ಬರ್ತೀರಾ ನೀವು ಅವತ್ತು?
Yes, my lord. Yes, my lord.
List on 23rd. Yes.
Great.
Yes.
Number 15, Praveen C.
On this 15, that military grant. Not the grant of land, my lord, according to them.
ಗೊತ್ತಾಯ್ತು. This
now one of the
Kargil.
One of the party, my lord, has not with their last. I think in the connected writ petition.
ಆಯ್ತು. That mother died ಅಲ್ಲ?
In the connected writ petitions, my lord, I think.
She's still there.
ಸ್ವಲ್ಪ ಏನೋ party.
ಅಲ್ಲ
ಅದು ಹೇಳ್ಬೇಕಲ್ಲ, ಅದನ್ನ ಕೋರ್ಟ್ ಹೇಳ್ಬೇಕು.
ಅಲ್ಲ 15.4 ಅಲ್ಲಿ this Muni Narayanamma, she's no more.
She's no more.
Yes, may I make submission, Lord?
In which matter, sir?
In writ petitions, that is in 15.4 and then 15.5, that Muni Narayanamma is dead. She died on 15/12/2024, please, Lord.
Yes, sir.
So I already filed LR application.
ಏನ್ ಮಾಡ್ತಾ ಇದ್ದೀರಾ? She's dead. One moment, sir.
Please, my lord.
What steps have you taken?
Lord, as far as they have.
It won't survive?
No, my lord, they have.
482, my lord, it gets abated. So far as she's concerned. Written ಹೇಳ್ಬೇಕಲ್ಲ, written they will have to, my lord.
Those are not 482.
ಅದು ಗೊತ್ತು ಸರ್, ಇಟ್ ಇಸ್ KLR. ಅದ್ರಲ್ಲಿ ಏನ್ ಸ್ಟೆಪ್ಸ್ ತಗೊಂತಾ ಇದ್ದೀರಾ?
Impleading application ಹಾಕಿದ್ದಾರೆ.
ಯಾರನ್ನ ಹಾಕಿದ್ದೀರಾ?
ಅವ್ರ ಮಕ್ಕಳನ್ನ 3 ಜನ ಮಕ್ಕಳನ್ನ ಹಾಕಿದ್ದಾರೆ.
ಕನ್ಸಿಡರ್ ಮಾಡ್ಬೇಕು. That can be allowed.
Yes. 15.4 ಅಲ್ಲಿ IA 1 of 2024 order on IA. The petitioner Srimati Muni Narayanamma is no more. Therefore, the petitioners have filed application seeking to bring the legal representatives as impleading application for the reasons indicated in the affidavit accompanying the application. The application stands allowed. The petitioner shall amend the cause title forthwith. Yes. Next.
My lord, so the same matter. My application is pending for my lord for impleading application.
No, that I have got objection, my lord.
Let him also come on record.
No, I've got some serious objections with regard to impleading application.
No.
They have impleaded themselves and we have.
Sir, ಎಲ್ಲರೂ ಹೇಳ್ಬೇಡಿ, ಒಂದೇ ನಿಮಿಷ.
May make one submission, Lord. In this LR application has been filed. I don't know whether it is not put up, I think, in all the cases.
Sir, LR application ಹಾಕಿದ್ದೀರಾ?
Now we have filed, my lord.
ಎಲ್ಲದರಲ್ಲೂ ಹಾಕಿದ್ದೀರಿ.
ಸರಿ. LR application.
So that has to be put up.
Let that be allowed. LR applications wherever they are filed, just check in ಇದು. ಮಾಡಿದ್ರೆ for the reasons indicated so and so allowed ಅಂತ ಮಾಡಿ. LR application ಎಲ್ಲದರಲ್ಲೂ.
And in some cases, In some cases, I have filed a memo reporting the death of Munnarayanamma, wherever I am respondent.
That's
And they
all
have to take steps.
Steps ಯಾಕೆ ಆಗ್ಲೇ ಹಾಕಿದ್ದಾರೆ ಎಲ್ಲಾರ ಅಪ್ಲಿಕೇಶನ್ ಅವರು.
ಅವರು ಹಾಕಿದೆ ಸರಿ. Now the question is, so far as the impleading application filed by one of the applicant, that I have got serious objection, I'll file it, or else that application may kindly be considered along with main.
All ಈಗ ಮಾಡಿ ಅದೊಂದು ಅಲೋ ಮಾಡ್ಬಿಡಿ ಎಲ್ಲಾರ ಅಪ್ಲಿಕೇಶನ್ಸ್ ಇದ್ರೆ. All other applications would be considered along with the main matter, including that of the impleading applicants. It is made clear that the impleading applicants would also be heard in the matter.
Please.
Yes. ಆಯ್ತಾ?
And interim order has to be extended.
Interim order will continue, sir. Don't worry. Yes. ಈಗೇನು ಹೇಳಿದ್ರು ಅದು impleading application so and so.
Kaushik appears and you are saying something.
That's Kaushik, is it?
Please.
Please.
Yes, Kaushik, what do you want to say?
Those impleading applications.
Okay, we'll hear you, don't worry. We'll hear you. Idu 23rd hakla?
Please.
List on 23rd.
Please, my lord. I had some submissions all on 15.2 ನಲ್ಲಿ.
14.2?
15.2.
ಏನಾಗಿದೆ?
I had not argued. I had sought time the other day when
That's all right. ಎಲ್ಲ ಒಟ್ಟಿಗೆ ಕೇಳೋಣ ಅವತ್ತು. Not today.
Please.
List all these matters on 23rd at 2:30 PM ಆಗ್ತೀನಿ. ಬೆಳಗ್ಗೆನೇ ಇರಲಿ 23rd ಪೂರ್ತಿ. List the matters on 23rd for further hearing.
Please.
Interim order to be extended.
Interim orders in all these cases subsisting will continue till the next date of hearing.
Grateful.
Grateful.
Yes, Adit.
Just for the petition. Request for a short accommodation.
23rd, my lord, this matter can also be taken up on 23rd, my lord.
23rd, sir, 23rd.
Interim order.
PPID Act also in this.
Prasann Kumar, sir, nimge yavudaru any other?
Interim order extension.
Any other matter?
17th on the serial number 17. Not filed by my colleague.
Your lordship, appear for the respondents.
Petitioner iga?
Petitioner.
Srinivasa K.
Please.
You appear for the petitioner.
No, please, I appear for the petitioner. This is
Lokayukta.
Lokayukta, not
Is 7A na 13 na?
This 7A. 7A.
23rd. Yes. Next.
Please.
18.
18.
Sandeep
Patil.
This will take time. Now, ಇನ್ನೊಂದು ಯಾವ್ದು ಹೇಳಿದ್ರಲ್ಲ ನೀವು ಪ್ರಸನ್ನ ಕುಮಾರ್? That also 23rd.
Please.
Serial number 21, my lords. I appear for the petitioner.
Interim order is extended, list on 23rd.
Please.
Not so, please, my lords. And both matters, my apology.
Both the matter.
There are two connect. Please.
Yes.
My apology.
ಆದ್ಮೇಲೆ ಒಂದಕ್ಕೆ ಕೊಡೋದು ಒಂದಕ್ಕೆ. Yes.
My apology.
Yes, next. 18. Yes. Professor sir ಇದಾರಲ್ಲ ಆನ್ಲೈನ್?
25, my lord, that
ಯಾವ್ದು ಬೇರೆ ಎಲ್ಲ 23rd ಹಾಕ್ತೀನಿ. This will take some time.
Yes, my lord.
Not Kalburgi bench matters.
ಅದು ಇದಾದ ತಕ್ಷಣ ತಗೊಂತೀನಿ. You finish your work and come.
Please.
My lord, serial number 24.
All on 23rd, sir.
Oh, of list.
Yes.
Lordship, serial number 1.
Mayur is here. Wait, I'll hear you. 23
Lord, serial number 19.
19, next matter. Wait, sir. Madhukar. What do you want?
My lord, I appear for the petitioners, my lord.
Madhukar, there is nothing left in this. Ella quash agi Supreme Court confirm madide. We'll close these cases. Umbilical cord is already cut. Yes. Yes, sir. Start 18. Submissions you tell you, madam. Yes.
No, before I take your lordship to the submissions which I am required to make, since I was not physically present either physically present on the previous date of hearing when professor argued. And
But,
I had to,
Swamini was there.
I had
She's made a
to
note.
take from my colleague, what are the submissions which came to be made by my friend Professor Ravi Verma Kumar. I shall first answer that, then I will go back.
Yes.
I think that would be better, my lord,
Yes.
by way of answer to that. Well, I am told, subject to what my lord would say and what Professor Ravi Verma Kumar would say, if I am wrong, I shall stand myself corrected. If I am right, my lord, I will proceed to make my submissions to the matter. The first submission which Professor Ravi Verma Kumar, the special public prosecutor for the state, appears to have made before your lordship on the previous date of hearing is, while taking your lordship to section 29 and 30 of the Protection of Children from Sexual Offences Act 2012, he would submit that the presumption that is found under section 29 and 30 of the Act would be raised right from the stage of the submission of the first information report, at the time of even taking cognizance, at the time of issuance of process, and even at the time of hearing the accused on the question of whether the charges have got to be framed or not, appears to be the submission which came to be made by my learned friend, while drawing my lord's kind attention to section 29 and 30 of the Act. Let me first deal with that submission, then I shall go to the second submission which he has made. Well, just to refresh my lord's memory, may I request your lordship to kindly turn to section 29 and 30 of the Act. At what stage the initial presumption that could be raised as found under section 29 and 30 is the question now. Is it at the time when the first information report is filed, or is it at the time of taking of cognizance, or is it at the time of issuance of process, or is it at the time of hearing the accused for the purpose of framing of charges against him is the question. Would your lordship kindly turn to section 29 of the Act first, where a person is prosecuted for committing or abetting or attempting to commit an offense under section 3, 5, 7, and 9 of this Act. Well, here in the instant case, the offense that is compliant is one under section 7, which is made penal under section 8 of the Act. The special court shall presume that such person has committed or abetted or attempted to commit the offense, as the case may be, unless the contrary is proved. Well, let me repeat it, the risk of repetition. Shall presume that such person has committed or abetted or attempted to commit the offense, as the case may be, unless the contrary is proved. But proof of contrary of the presumption would arise not at the stage of the filing of the first information report, or at the stage of taking of cognizance, or issuance of process, or at the time of hearing of the request of the accused for an order of discharge. Now kindly go to section 30 of the Act now. Presumption of culpable mental state. Before that, may I draw your lordship's attention to section 7 of the Act, how sexual assault has been defined. May I request your lordship to kindly go to section 7 of the Act. Whoever with sexual intent. Well, here your lordship would get whoever with sexual intent. The intention becomes the paramount consideration to constitute the act of sexual assault that is attributed to the accused, as found under section 7, which is made penal under section 8. Now kindly go to section 30 now. Presumption of culpable mental state. In any prosecution for any offense under this Act, which requires a culpable mental state on the part of the accused, the special court shall presume the existence of such mental state, but it shall be a defense for the accused to prove the fact that he had no such mental state with respect to the act charged as an offense in that prosecution. But when presumption for an offense under for the violation of the provisions of section 7, which is made penal under section 8, could be raised under section 29 only during the trial for the purpose of finding out whether what was his mental state, what was his intention. Well, it can't be prior to the trial under section 30. Lord, may I invite your lordship's attention to the very judgment which my learned friend has placed reliance. The first judgment on which my learned friend has placed reliance is the judgment of the Supreme Court in 2022, Volume 5 Supreme Court cases 545. That is in Attorney General of India's case. May I request your lordship to kindly turn to paragraph 39 in this judgment. 39. When the presumption could be raised is what the full bench of the Supreme Court has said in 2022, Volume 5 Supreme Court cases 545.
ಅಲ್ಲಿದೆ ನೋಡಿ ಅದು. Volume 1.
Your lordship may kindly turn to ink page 301 of the compilation.
I'm there.
30, paragraph 39.
Yes.
Kindly permit me to take your lordship to this paragraph. It's a very small paragraph. It may also be pertinent to know that having regard to the seriousness of the offences under the POCSO, the legislature has incorporated certain statutory presumptions. Section 29 permits the special court to presume when a person is prosecuted for committing or abetting or attempting to commit any offence under sections 3, 5, 7, and 9 of the Act, that such person has committed or abetted or attempted to commit the offence, as the case may be, unless the contrary is proved. Similarly, Section 30 of the thereof permits the special court to presume for any offence under the Act which requires a culpable mental state on the part of the accused, the existence of such mental state.
Yes.
Of course, the accused can take a defense and prove the fact that he had no such mental state with respect to the act charged as an offence in that prosecution. It may further be noted that though as per subsection 2 of section 30 for the purpose of the said section, a fact is said to be proved only when the special court believes it to exist beyond reasonable doubt and not merely when its existence is established by a preponderance of probability. The explanation to section 30 clarifies that culpable mental state includes intention, motive, knowledge of a fact, and the belief in or reason to believe a fact. Thus, in the conjoint reading of section 7, 11, 29, and 30, there remains no shadow of doubt that though as per explanation to section 11, sexual intent would be a question of fact, the special court, when it believes the existence of a fact beyond reasonable doubt, can raise a presumption under section 30 as regards the existence of culpable mental state on the part of the accused. So when does that come into play? Beyond all reasonable doubt, they have got to be. That means basic foundational aspects must be laid, that's all. Not now, my lord, for the purpose of when the accused invokes my lord's jurisdiction under 482 or under section 226, read it, there is a presumption. No, that is incorrect, would be my respectful submission. My lord, may I now invite your lordship's kind attention to the second judgment on which my learned friend has placed reliance, that is in 2024, SCC Online SC 2611. First, I would like to draw my lord's kind attention to paragraph 188. Kindly go to paragraph 188 at ink page 127. Sorry, 128. Para 188. My lord gets it.
Yes.
Yes. As has been held in Prakashnath Khanna and Ratish Babu Unni Krishnan, any defense of the accused for the purpose of rebutting the said statutory presumption should ordinarily be left to the trial court to be looked into, at least when it comes to the quashing of petitions. Though in certain exceptional circumstances, the High Court may entertain such defense to quash the criminal proceedings, where it appears from the facts itself, but kindly mark this, where it appears from the facts itself that the allegations themselves are completely false and bogus and by no stretch of imagination said to be established. But in doing so, the High Court must be slow and circumspect and must exercise some restraint. The statutory presumption may be ignored only where no foundational facts have been established from the material on record. Well, I may now request your Lordship to kindly turn to paragraph 196 at page 131.
Yes.
The High Court in its impugned order, while quashing the criminal proceedings arising out of the aforesaid charge sheet dated 19/9/2023, completely failed to advert to the actual charge that was alleged therein, more particularly section 15 subsection 1 of POCSO. Instead, the High Court appears to have just relied upon, kindly mark this, my lord. Instead, the High Court appears to have just relied upon the FIR and premised its findings on section 14 of the POCSO, even though the said offense had been dropped in the charge sheet. Thus, there appears to be a serious lapse on the part of the High Court in failing to advert to section 15 of the POCSO, especially, my lord, kindly mark this, especially when the charge sheet had already been filed at the time of passing the impugned order. But in the instant case, the charge sheet has already been filed. The petitioner was before your lordship at a point of time when the first information report was filed. Subsequently, during the pendency of those proceedings, a charge sheet came to be filed. My lord, the petition ultimately came to be amended, seeking quashing of the order of taking of cognizance. The court thereafter, kindly note this, my lord, it is no longer res integra that once the investigation is over, kindly underline this, it is no longer res integra that once the investigation is over and charge sheet is filed, the FIR pales into insignificance. The court thereafter owes a duty to look into all the materials collected by the investigating agency in the form of charge sheet. But probably this would answer the doubt, if any, that would have crept in the mind of the public prosecutor that you can't look into the charge sheet materials other than the first information report in the case. Lastly, my lord, may I request your lordship to kindly turn to paragraph 202. My lord, your lordship will get it at page 134, in page 134 of my compilation, paragraph 202. The High Court should neither be picky nor remain oblivious in deciding which provision to advert to while considering a quashing petition. When dealing with a quashing petition, there lies a duty in the High Court to properly apply its mind to all the material on record. The least which is expected of the High Court in such a situation is to carefully go through the allegations contained in the FIR and the charge sheet and to ascertain whether the offences alleged therein could be said to have been prima facie established from the material on record. Number two, whether apart from the offences alleged in the FIR or the charge sheet, there is possibility of any other offence prima facie being made out. The High Court, in exercise of its inherent powers, may be justified in quashing the criminal proceedings where neither an offence is as alleged in the FIR or in the charge sheet is disclosed, nor any offence is prima facie made out, and the continuance of the proceedings may be found to amount to abuse of process of law. But a combined reading of the law laid down by the Supreme Court in these two judgments, well, in 2024, in the case of Just Rights for Children Alliance, the full bench judgment of the Supreme Court has not been referred to at all with regard to the presumption that could be raised under section 29 and 30 of the POCSO. But one of the finest judgments, on which I have been able to lay my hands is that of the Allahabad High Court. May I request your lordship to kindly turn to ink page 42 of the judgment of my company. Kindly go to, my lord, your lordship may kindly go to next page, page 23, paragraph 49. This is in 2023.
Which paragraph?
I'm sorry, madam.
Paragraph, sir.
Paragraph 49.
49.
49. I think page 23 at the top.
Yes.
The time-honored and time-tested rule of evidence that no presumption is absolute and every presumption is rebuttable forms the basis of the judgment rendered by Manish Pitale, J. in Naveen Dhaniram Murthy, etc. versus State of Maharashtra, while interpreting the scope of presumption of culpable intent under Section 29 of the POCSO Act. A perusal of the above quoted provision does show that it is for the accused to prove the contrary, and in case he fails to do so, the presumption would operate against him, leading to his conviction under the provisions of the POCSO Act. It cannot be disputed that no presumption is absolute and every presumption is rebuttable. It cannot be countenanced that the presumption under Section 29 of the POCSO Act is absolute. It would come into operation only when the prosecution is first able to establish facts. When can they establish? It's only during the trial, not at this preliminary stage. Facts that would form the foundation for the presumption under Section 29 of the POCSO Act to operate. Otherwise, all that the prosecution would be required to do is to file a charge sheet against the accused under the provisions of the said Act, and then claim that the evidence of the prosecution witnesses would have to be accepted as gospel truth, and further that the entire burden would be on the accused to prove the contrary. That means it is only upon conclusion of the trial, my lord, the burden shifts upon the accused, and therefore a presumption could be raised under Section 29 and 30. Now kindly read the next sentence, my lord. Such a position of law, interpretation of the presumption under Section 29 of the POCSO Act cannot be accepted, as it would clearly violate the constitutional mandate that no person shall be deprived of liberty except in accordance with the procedure established by law. The above quoted views of the courts elucidate the position of law in so far as presumption under Section 29 of the POCSO Act is concerned. It becomes clear that although the provision states that the court shall presume that the accused has committed the offense for which he is charged under the POCSO Act, unless the contrary is proved, the presumption would operate only upon the prosecution first proving the fundamental facts against the accused beyond reasonable doubt. Unless the prosecution is able to prove foundational facts in the context of the allegations made against the accused under the POCSO Act, the presumption under Section 29 of the said Act would not operate against the accused. Therefore, my lord, at this point of time, when the accused petitioner is seeking for the quashing of an order passed by the trial court, my lord, taking of cognizance and issuance of process against him, vis-a-vis quashing of the first information report that is filed in the case, so the prosecution cannot, my lord, seek the presumption that inures to its benefit under Section 29 and 30 of the Act, which could be raised only upon conclusion of recording of evidence. It is only then, my lord, that the burden shifts upon the accused, would be my answer to the submissions which came to be made by my learned friend. Well, the other submission which came to be made, the second submission which came to be made by my learned friend is, while taking your lordship to the record of the case, that is, my lord, your lordship may recall to your lordship's memory, the very first day I submitted to your lordship, just to recapitulate, because it may become necessary for me to answer the submission which came to be made by my learned friend. The offense would take place on 2/2/2024.
No, learned friend may take the mic.
He is on the mic.
Mic.
He ಕೇಳಿಸ್ತಾ ಇದೆಯಾ sir?
ಹೌದು ಕೇಳಿಸ್ತು. ಈಗ ಕೇಳಿಸ್ತು.
Very good. 2/2/24, between 11 and 11:30, they will go out. Both mother and daughter would come back. After they come back, well, why did they come back? Not for the purpose of recording any conversation between the petitioner on the one hand and the mother of the victim on the other hand. No. the object or the purpose of their second visit on that day, ಅವತ್ತು ಬಂದು ಉದ್ದೇಶ ಯಾತಕ್ಕೆ ಅಂತಂದ್ರೆ ಪಿಕ್ಚರ್ ತಗೋಬೇಕು ಅಂತ ಅಷ್ಟೇ, ಇನ್ನೇನಿಲ್ಲ. ದಟ್ ವಿ ಡಿಸೈರ್ ಟು ಹ್ಯಾವ್ ಎ ಪಿಕ್ಚರ್ ವಿತ್ ಯು, ದೇರ್ ಫೋರ್ ವಿ ಹ್ಯಾವ್ ಕಮ್ ಬ್ಯಾಕ್ ಅಂತ. ವಾಟ್ ಮಿಸ್ಚೀಫ್ ದೇ ಡಿಡ್, ಐ ವಾಸ್ ನಾಟ್ ಅವೇರ್ ಆಫ್ ಇಟ್ ಅಟ್ ಆಲ್. ವಾಟ್ ಮಿಸ್ಚೀಫ್ ದೇ ಡಿಡ್, ಐ ವಾಸ್ ನಾಟ್ ಅವೇರ್ ಆಫ್ ಇಟ್ ಅಟ್ ಆಲ್. They take a picture, go away. But
No.
before they go away,
they come back not only to take the picture but to question you about what you did to the daughter.
ಮತ್ತೆ ಅದಕ್ಕೆ ಉತ್ತರ ಹೇಳ್ತೇನೆ. ಅದನ್ನ ನೆಕ್ಸ್ಟ್ ಅದೇ ಈ ಉತ್ತರ ಹೇಳಕ್ಕೆ ಇದನ್ನ ಬ್ಯಾಕ್ಗ್ರೌಂಡ್ ನ ಹೇಳ್ತಾ ಇದ್ದೀನಿ. Just to answer that, in fact, your lordship posed that question to me on the previous day also. Check ಮಾಡೋದು ಏನು ಅಂತ ಅಂದ್ಬಿಟ್ಟು. That is how my lord has posed the question. I am bound to answer, my lord, that question or the doubt which my lord has entertained in your lordship's judicial mind. What would happen on that day? I would tell, ನಾನು ಹೇಳ್ತೀನಿ, ಏನಂತ ಹೇಳ್ತೀನಿ, ಅಮ್ಮ ನಿನ್ನ ಗ್ರೀವೆನ್ಸ್ ಏನು, ಯಾತಕ್ಕೋಸ್ಕರ ಬಂದಿದೀಯಾ ಹೇಳ್ತೀನಿ. Then my lord, police commissioner ಕರಿತೀನಿ ಫೋನ್ನಲ್ಲಿ. I would call the commissioner of police of Bangalore city. I said, look here, ನೋಡಿ ನನ್ನ ಮುಂದೆ ಇಬ್ಬರು ಹೆಣ್ಮಕ್ಳಿದ್ದಾರೆ, ಅವ್ರಿಗೇನೋ ತೊಂದರೆ ಆಗಿದೆ, ಅವರಿಗೆ ಯಾರು ಏನೋ ಅದರ ಬಗ್ಗೆ ಕ್ರಮ ಜರುಗಿಸ್ತಾ ಇಲ್ಲ, ದಯಮಾಡಿ ತಾವು ಅದನ್ನು ನೋಡಿ ಅಟೆಂಡ್ ಮಾಡಿ ಕಾನೂನು ಪ್ರಕಾರ ಏನಿದೆಯೋ ಆ ಕ್ರಮ ಜರುಗಿಸ್ಬೇಕು ಅಂತ ಅಂದ್ಬಿಟ್ಟು ಅಂತ ಐ ವುಡ್ ಆಸ್ಕ್ these two ladies to go to the commissioner of police. ಹೋಗ್ತಾರೆ ಅವರು. On the very same day they go to the commissioner of police, Bangalore city, pursuant to my request with the commissioner of police. The commissioner of police would listen to them for some time, which is not. But even on that day, avattu, if really any such incident in the manner spoken to by these two persons, either in their statements or in the first information report, had happened, when they could go and meet the city police chief of Bangalore city on that day, would they have failed to make a mention of it? Adana ಅವರು ಹೇಳದೇ ಇರ್ತಾ ಇದ್ರ ಅನ್ನೋದು ಮೂಲಭೂತ ಪ್ರಶ್ನೆ. That would certainly create a doubt with regard to the conduct of the victim and her mother. That is how, my lord, I submitted to your lordship the other day. ಹೇಳೋದಿಲ್ಲ. Then they will come back. But again, ಎರಡನೇ ಸಾರಿ they would come and visit me on 5th of February 2024. 5th of February 2024. Again for what? Picture. One of my attendants in my house, my lord, was asked to take a picture. They wanted a picture along with me. Yes, they would take a picture. If really any such incident had happened on 2-2, well, would they have come? Well, it defies elementary logic and common sense would be my respectful submission.
They did not come only for the picture. ಅಲ್ಲಿ question answer ಇದೆ.
ಅದಕ್ಕೆ ಬರ್ತೀನಿ ಈಗ.
Mobile recording and question answer.
ನೋ ಅದಕ್ಕೆಲ್ಲ ಬರೋ ಉದ್ದೇಶ ಕೇಳೋದಕ್ಕೆಲ್ಲ ಬರೋದವರು. ಉದ್ದೇಶ ಸ್ಟೇಟ್ಮೆಂಟ್ ಇರೋದ್ರಲ್ಲಿ ನಾನು ಕ್ವಶನ್ ಅಂಡ್ ಆನ್ಸರ್ ಮಾಡಿ ಕೇಳೋದಕ್ಕೆ ಬಂದೆ ಅಂತ ಅಲ್ಲ ಇರೋದು. Her statement, my lord, I was ready to take your lordship to the statement of the witness since I am responding to the submissions which came to be made by my learned friend, my lord. I'm just, no, they don't come for the purpose of putting a question to me or recording the question and the answer which I would be giving. They would come, my lord, again for the purpose of picture. Like really. Even on 5th also, when I have talked to the commissioner of police, what did you do? Again, these two ladies are before me. Please take action against them. They would go back. But clandestinely, doesn't matter. What is the recording we will see? Clandestinely, a recording is said to have been made by this lady or by that prosecutrix of certain questions which came to be posed to me and the answers which came to be given by me. It is on record in the case. Your lordship may take it from me. At this point of time, I am not disputing it at all. Therefore, the question of the experts or the scientific officers who are attached to the forensic science laboratory giving an opinion, no, look here, taking the voice sample of the petitioner accused before your lordship, no, it matches, therefore, it is his voice. No, I have nowhere denied it. Well, it is apparently evident from the question and answer which came to be recorded, which were put to the accused petitioner subsequently during the course of the investigation of the crime itself would indicate, yes, there was a conversation. So therefore, my lord, I am respectfully submitting, it is not in dispute. It is not a great thing for the prosecution to contend.
All right. It is admitted that the voice sample or whatever there is, if you are admitting that, you should admit the questions that she has posed and your answers given to that.
Next, my next endeavor is that, my lord. My next endeavor is only that. My lord, that is on 5th, my lord. Again on 20th, they will come to me. 20th February. first, second, fifth, 20th. But imagine the situation, my lord. A lady who had met with an act of sexual assault at my hands. But what I am submitting to your lordship is, there is a court of law, there is a court of justice. I am sure your lordship would certainly agree with me if I were to put it, my lord. It cannot even appeal to a layman. It defies elementary logical common sense. They are coming to me time and again, time and again, time and again.
No, are you suggesting that such a thing, happening of such a thing is highly improbable?
That's it.
That's
Right?
your submission.
They're highly improbable. It has got to be rejected lock, stock and barrel, not on account of that conduct alone. The Lord may kindly say, I'm not for a moment saying that their conduct in not coming out with a complaint and 2-2, their conduct in not coming out with a complaint and 5-2, their conduct in not coming out with a complaint and 22, but their conduct in waiting for another 1.5 months to file a complaint against me has got to be seen, my lord, coupled with the other evidence that is available on record in the case and the past conduct of the first informant in the case, who filed 56 complaints or petition against various persons and authorities of the state. Well, on 20th they will come. But on 5th also, in between 2nd and 20th, she was in contact with any number of persons, including her lawyer. She does not disclose it to the lawyer, Mr. R.R. Hiremat, who has been examined as one of the prosecution witnesses. Well, and now let us come back, because your lordship posed a question to me. Now let us come back, having admitted by you in your statement, which came to be recorded, but howsoever it is relevant, that is a different issue. The fact remains that there is a statement of the accused. May I request your lordship to kindly turn to the recorded version first, and then I shall take your lordship to the statement of the accused. But your lordship would get that. Kindly take my learned friend, Professor Ravivarma read it. Well, my compilation, convenience compilation, at page 130.
Yes, sir.
130. Commences at page 130. Really?
The mobile recording.
Yes, yes, mobile recording. Page 130. ಅಪ್ಪಾಜಿ ಇಲ್ಲೇ ಇದ್ರ ಏನ್ ಮಾಡಿದ್ರಿ ಅಲ್ಲಿ
ಯಾರ ಜೊತೆಗೆ ಮಾತನಾಡಿದೆ ಅದ
ಒಳಗೆ ಕರ್ಕೊಂಡು ಹೋಗಿ ಏನ್ ಮಾಡಿದ್ರು ಕೇಳು ಏನ್ ಮಾಡಿದೆ ನನ್ನ ಮೊಮ್ಮಗಳಿದ್ದಂಗೆ ಅವಳು ನನ್ನ ಮೊಮ್ಮಗಳಿದ್ದಂಗೆ ಅಲ್ಲ ಮರಿ ಲಾಸ್ಟ್ ಸೆಂಟೆನ್ಸ್
BSY
ಅಲ್ಲ ಮರಿ ಒಂದ್ ನಿಮಿಷ ಹೇಳ್ತೀನಿ ಕೇಳು ನೀನೇನ್ ತಲೆ ಕೆಡ್ಸ್ಕೋಬೇಡ ನನಗೆ 7 ಮೊಮ್ಮಕ್ಕಳು ಇದ್ದಾರೆ ತುಂಬಾ ಒಳ್ಳೆ ಹುಡುಗಿ ಅವಳು ನೋಡಿದೆ ಅವಳು ಚೆನ್ನಾಗಿ ಏನ್ ಬೇಕು ಅದು ನಾನು ಸಹಾಯ ಮಾಡ್ತೀನಿ. But this would be next question and answer is the one which came to be posed by my lord to me the other day to answer it. Well, first is that ಇಲ್ಲ ಮರಿ then my lord ಅಪ್ಪಾಜಿ ಎಲ್ಲರೂ ಹಿಂಗೇನ
ಅಲ್ಲಿ ಮೇಲಿದೆಯಲ್ಲ
ಹೌದು
ಅವಳ
ಅದನ್ನ ನಾನು
ಕೈ ಹಾಕಿ
since your lordship is reading it, I thought, my lord, I should not only for that limited purpose. Not that I don't want to read it, because your lordship would always direct us. Don't.
ಅವ್ರಿಗೂ ಅದನ್ನೇ ಹೇಳಿದೆ, don't read those.
ತಾವೇ ಡೈರೆಕ್ಷನ್ ಕೊಡ್ತೀರಿ, ಅದೆಲ್ಲ ಏನು ಬೇಡ, ನಾನು ನೋಡ್ಕೋತೀನಿ, ಪರವಾಗಿಲ್ಲ ಅಂತ ಅಂದ್ಬಿಟ್ಟು. This answer I can read. Certainly, this answer I can read. ಅವಳು ನನ್ನ ಮೊಮ್ಮಗಳಿದ್ದಂಗೆ ತುಂಬಾ ಒಳ್ಳೆ ಹುಡುಗಿ, ಚೆಕ್ ಮಾಡಿದೆ, ಅವಳಿಗೆ ಮುಂದೆ ಒಳ್ಳೇದಾಗತ್ತೆ, ಅದೇನ್ ಬೇಕು ನಾನು ಸಹಾಯ ಮಾಡ್ತೀನಿ, ಚೆನ್ನಾಗಿ ಅವಳನ್ನ ನೋಡ್ಕೊ. ಇಲ್ಲಿ probably, I don't know whether how far I should be justified in making this submission. It is this sentence that is disturbing the mind of the court. I don't know.
ಚೆಕ್ ಮಾಡಿದೆ.
It is that which is appears to be disturbing because of the questions which came to be posed to me. Now kindly go to page 132 at the top.
132.
132. Very next page, my lord, at the top.
Yes, ನಾನು ಹೇಳ್ತೀನಿ.
ನಾನು ಹೇಳ್ತೀನಿ ಕೇಳು. ಬಹಳ ಒಳ್ಳೆ ಹುಡುಗಿ ಅವಳು. ನಾನ್ ನೋಡ್ದೆ, ಚೆಕ್ ಮಾಡಿದೆ, ಯಾವುದೇ ಕಾರಣಕ್ಕೂ ಸಹ ಯಾರಿಗೊಬ್ಬರಿಗೂ ಬಿಟ್ಕೊಡಲ್ಲ. ಚೆನ್ನಾಗಿ ಬೆಳೆಸು. ನಾನು ಏನ್ ಬೇಕೋ ನಾನು ಮಾಡ್ತೀನಿ. ಪ್ರಯತ್ನ ಅಲ್ಲ, ಇದನ್ನ ಬಸವರಾಜ ಬೊಮ್ಮಾಯಿ ಅವರೇ ಮಾಡ್ತೀನಿ ಅಂತ ಹೇಳಿದ್ರು. ಅವಾಗ್ಲೇನೆ ಅವ್ರಿಗೆ ನನ್ನ ಬಗ್ಗೆ ಸುಳ್ಳು ಕ್ರಿಯೇಟ್ ಮಾಡಿ, ಈಗ ಮುಗೀತಲ್ಲಮ್ಮ, ಯಾರಿಗೆ ಹೇಳ್ಬೇಕು ಈಗ? ಸರ್ಕಾರಕ್ಕೆ ಹೇಳಿ. But what is it that he checked?
That's the mystery.
Yes, no. The answer is here. Your lordship would get the answer. It was not brought to your lordship's notice the other day when the submissions came to be made by the respondent. May I request your lordship to kindly take the questionnaire which came to be recorded on 17/6/2024.
The petitioner.
Yes, my lord.
Yes.
17/6/2024. My lord, as my lord has entertained the doubt, the investigator also did entertain some doubt. How do you answer these questions? What is it that you have checked? He goes on asking question after questions. Probably had he not put these questions and elicited this answer, this doubt would have continued to remain on the record of the case. He got it clarified. May I request your lordship to kindly go to
Question number
17 first. Kindly go to question number 17.
ಆಡಳಿತ ಪಕ್ಷದ ರಾಜಕಾರಣಿಗಳದ.
ಹೌದು, ರಾಜಕಾರಣಿಗಳನ್ನು ಬಿಟ್ಟು ನಿಮ್ಮ ಹತ್ತಿರ ಸಹಾಯ ಕೇಳಲು ಬಂದಿರುವ ಕಾರಣವೇನು?
ಫಾರ್ಮರ್ ಸಿಎಂ ಅಂತ ಹೇಳಿದ್ರು.
ನಾನು ಒಬ್ಬ ಮಾಜಿ ಮುಖ್ಯಮಂತ್ರಿ, ನನ್ನಿಂದ ಏನಾದರೂ ಸಹಾಯ ಆಗಬೇಕೆಂದು ಬಂದಿರಬಹುದು. ನೆಕ್ಸ್ಟ್ ಕ್ವಶನ್. ಮಮತಾ ಸಿಂಗ್ ಅವರ ಜೊತೆ ಅವರ ಮಗಳ ಕೈ ಹಿಡಿಯಲು ಕಾರಣವೇನು? ಮಗುವಿಗೆ ಆದ ಅನ್ಯಾಯದ ಬಗ್ಗೆ ವಿಚಾರಿಸಲು ಆಕೆಯ ಕೈಯನ್ನು ಹಿಡಿದುಕೊಂಡು ಮಾತನಾಡಿಸಿರುತ್ತೇನೆ. ದಟ್ ಇಸ್ ನೋ. ಮಮತಾ ಸಿಂಗ್ ರವರನ್ನು ಮಗಳೊಂದಿಗೆ ಯಾಕೆ ಒಳಗೆ ಕರೆದಿಲ್ಲ? ದಿಸ್ ವಿಲ್ ಬಿ ವೆರಿ ವೆರಿ ಇಂಪಾರ್ಟೆಂಟ್. ಕೈಂಡ್ಲಿ ಮಾರ್ಕ್ ದಿಸ್, ಮೈ ಲಾರ್ಡ್. ಯಾರನ್ನೂ ರೂಮಿನ ಒಳಗೆ ಕರೆದುಕೊಂಡು ಹೋಗಿರುವುದಿಲ್ಲ. ದಟ್ ಈಸ್ ಹಿಸ್ ಸ್ಟೇಟ್ಮೆಂಟ್. ಎಂಫೆಟಿಕ್ ಡಿನೈಲ್ ಆಫ್
No, it's a statement versus statement. She has rendered a statement. You have
kindly
rendered
go
a
to question number 21 now. Kindly go to question number 21. 2/2/24 ಎರಡನೇ ಬಾರಿಗೆ ಬಂದಾಗ ನಿಮ್ಮನ್ನು ನನ್ನ ಮಗಳಿಗೆ ಏನು ಮಾಡಿದ್ರಿ ಎಂದು ಕೇಳಿದಾಗ ನೀವು ಏನು ಉತ್ತರ ನೀಡಿದ್ದೀರಿ? ಯಾಕಮ್ಮ, ಏನಾಗಿದೆ, ನಾನೇನು ಮಾಡಿದೆ, ಹುಚ್ಚಾಗಿ ಏನೇನೋ ಮಾತನಾಡಬೇಡ ಎಂದು ಹೇಳಿರುತ್ತೇನೆ. ನಾವು kindly go to question number 23. ಮಮತಾ ಸಿಂಗ್ ರವರು ನಿಮ್ಮ ವಿರುದ್ಧ ಫೇಸ್ಬುಕ್, ಸೋಷಿಯಲ್ ಮೀಡಿಯಾದಲ್ಲಿ ವಿಡಿಯೋವನ್ನು ಬಿತ್ತರಿಸಿದ್ದು ನಿಮಗೆ ಯಾವಾಗ ಗೊತ್ತಾಯಿತು? ಯಾರು ಮಾಹಿತಿ ನೀಡಿದರು? ಟಿವಿ ಮಾಧ್ಯಮಗಳಲ್ಲಿ ಬಂದ ಮೇಲೆ ತಿಳಿಯಿತು, ಆದರೆ ಈ ಬಗ್ಗೆ ಯಾವುದೇ ಕ್ರಮವನ್ನು ತೆಗೆದುಕೊಂಡಿರುವುದಿಲ್ಲ. Kindly now go to question number 29. Here, your lordship would get the answer to the doubt which came to be expressed by my lord the other day. ಮಮತಾ ಸಿಂಗ್ ರವರು ಈ 2 ಲಕ್ಷ ರೂಪಾಯಿಗಳನ್ನು ಯಾವ ಕಾರಣಕ್ಕಾಗಿ ನೀಡಿರುತ್ತೀರಿ? ನೀವು ನೀಡಿದ ಹಣದ ಡಿನಾಮಿನೇಷನ್ ಏನಾಗಿತ್ತು? ಮಮತಾ ಸಿಂಗ್ ರವರು ತನಗಾದ ಅನ್ಯಾಯದಿಂದಾಗಿ ತನಗೆ ಮನೆ ಬಾಡಿಗೆ ಕಟ್ಟಲು, ಕರೆಂಟ್ ಬಿಲ್ ಕಟ್ಟಲು ಕಷ್ಟವಾಗುತ್ತಿರುವುದಾಗಿ ತಿಳಿಸಿ ಕಣ್ಣೀರು ಹಾಕಿದ್ದರಿಂದ ನಾನು ಅದನ್ನ ನನ್ನ ಜೊತೆಗೆ ಇದು ರುದ್ರೇಶ್ ಅವರಿಗೆ ನಿಮ್ಮ ಕಡೆಯಿಂದ ಏನಾದರೂ ಸಹಾಯ ಮಾಡಿ ಎಂದು ಹೇಳಿದೆ. ಆಗ ರುದ್ರೇಶ್ ಅವರು 2 ಲಕ್ಷ ಹಣವನ್ನು ಆಕೆಗೆ ಸಾಲವಾಗಿ ಕೊಟ್ಟಿರುತ್ತಾರೆ. But in her statement also your lordship would get that Rudresh gave her rupees 2 lakhs by way of loan. Now my lord, ಮಮತಾ ಸಿಂಗ್ ರವರು ನಿಮಗೆ ಭೇಟಿಯಾದಾಗ ಯಾವತ್ತಾದರೂ ಹಣದ ಬೇಡಿಕೆ ಇಟ್ಟಿದ್ದರೆ? ಇಲ್ಲ. ಆದರೆ ನಮ್ಮ ರುದ್ರೇಶ್ಗೆ ದುಡ್ಡು ಬೇಕು ಎಂದು ಆಗಾಗ್ಗೆ ಬೇಡಿಕೆ ಇಟ್ಟು ಮೆಸೇಜ್ ಮಾಡಿರುವುದಾಗಿ ತಿಳಿಸಿರುತ್ತಾರೆ. My lord, probably this should clarify question number 31.
ಚೆಕ್ ಮಾಡಿದ ಕ್ಲಾರಿಫಿಕೇಶನ್
ಇದೆಯಲ್ಲ, ವಿಡಿಯೋದಲ್ಲಿ ಚೆಕ್ ಮಾಡಿದ ಬಗ್ಗೆ ಹೇಳಿರುತ್ತೀರಿ. ಏನನ್ನು ಚೆಕ್ ಮಾಡಿರುತ್ತೀರಿ? ಇದೆ ಪಕ್ಕದಲ್ಲಿ ಕೂರಿಸಿಕೊಂಡು ಕೈ ಹಿಡಿದುಕೊಂಡು ಏನೆಂದು ಕೇಳಿದೆ. ಮಗು ಆ ಬಗ್ಗೆ ಏನು ಹೇಳಲಿಲ್ಲ. ತಾಯಿಯೇ ತನ್ನ ಮಗಳ ಪೋಕ್ಸೋ ಕೇಸಿನ ಬಗ್ಗೆ ತಿಳಿಸಿದ್ರು. ಕೇಸಿನ ಬಗ್ಗೆ ಚೆಕ್ ಮಾಡಿದೆ ಎಂದು ಅವ್ರು ಬಂದಿದ್ದು. ದಿ ಆಬ್ಜೆಕ್ಟ್ ಆಫ್ ದಿ ಪರ್ಪಸ್ ಆಫ್ ದೇ ವಿಸಿಟಿಂಗ್ ಹಿಮ್ ಈಸ್ to get his assistance or help by using his contacts or the influence with the public authorities with regard to the earlier case of rape.
So he was checking out about the case.
From her. ಅವಳ ಹತ್ರ ಮಾತಾಡ್ಲಿಲ್ಲ, ಚೆಕ್ ಮಾಡಿದೆ ಅಂತ. That is the answer which your lordship would get at this point of time. But probably the
The
rest,
statement is disturbing in what mobile recording is there. Check ಮಾಡ್ದೆ ಒಳ್ಳೆ ಹುಡುಗಿ ಯಾರ ಹತ್ರನೂ ಕಳಿಸ್ಬೇಡ ನಾನೇ ನೋಡ್ಕೊಂತೀನಿ. Why all that?
my lord, I did not ask.
ಅಲ್ಲ
Yeah.
ಮೊಬೈಲ್ ರೆಕಾರ್ಡಿಂಗ್ ನಿಮ್ದೇ ವಾಯ್ಸ್.
ಹೌದು ಕೇಳಿದಾರೆ ಅವ್ರು ಬಂದು, ನಮಗೇನ್ ಗೊತ್ತು, ರೆಕಾರ್ಡಿಂಗ್ ಮಾಡಿರೋದೇ ಗೊತ್ತಿಲ್ವಲ್ಲ ನಮ್ಗೆ.
ಅಲ್ಲ ಗೊತ್ತಿದ್ರೆ ಅದೇ
I did not deny it. I did not deny it.
No, that is
I have
true.
said it,
But
you have
it
done
is
it.
your statement.
That is my statement. The explanation which you would get from me, the investigator himself, is what is it that you have checked? Because you have said, kindly read it once again. Videoದಲ್ಲಿ ಚೆಕ್ ಮಾಡಿರೋ ಬಗ್ಗೆ ಹೇಳಿ ಹೋಗ್ತೀರಿ.
This is there.
It is there. He would ask me.
But
if I may say so.
This interpretation of checking, if accepted.
Yes. Well, that is not the issue now. Well, it is not only that, because how the Supreme Court has said is, I invited my lord's attention.
Yes, all that.
Solely on the basis of the 164 statement, or on the basis of the statement of the victim under 161, nothing could be done. The overall evidence with the investigator collected, if that were to be contrary to or belies the statement of the victim or the first informant, it has got to be accepted. That is how, my lord, I submitted to your lordship. What is investigation, my lord? I am posing that question to myself. Collection of evidence.
No, it's collection of evidence.
He collects evidence to the allegation which the first informant has made. Otherwise, my lord, in every case, if that were to be accepted as gospel truth,
No, it can't
investigation
be.
is necessary.
Gospel truth on both ways cannot be accepted.
Right. No, not on both.
Whether the accused says so or whether the victim says so. Collection of evidence is the evidence that is recorded by the investigating officer, unless it is put to test, is what I am.
But what I am submitting to your lordship, it is not the evidence of the accused.
No, it's
It is not
evidence.
the defense
no,
evidence.
It's evidence
Evidence of the prosecution.
it's evidence of the complainant witnesses.
Yes, compliance witnesses. It is the evidence which the investigator would collect on behalf of the prosecution to ascertain or to find out as to what the
That can form a part of proceedings to quash under 482.
That is how, my lord,
Yes, that's what.
even in this judgment also.
Yes, even that.
I said entire charge sheet material has got to be seen. The evidence, my lord, that is in 2022, the subsequent judgment of justice.
All was well, but for the recording that is there of the mobile phone.
Quite right, my lord. But the explanation is here. But there are 5 eyewitnesses to the
Yes,
persons.
5 prosecution witnesses.
Prosecution witnesses were present. Everyone, but in one breath, in one voice, they would say, nothing happened on that day. All of us were sitting in the drawing room. These 2 ladies came. After they were attended to and sipping a cup of tea, they left the place. Why, my lord? They should be discarded at this point of time. Why the sole statement of the victim needs to be accepted if that statement of the victim does not get any corroboration whatsoever from the other evidence that was available and with the investigator collected during the course of the investigation of the crime would be my respectful submission.
Yes.
My lord, I have also submitted to your lordship the other day. Lord, one president of the Working Journalists Association, Mr. Shivananda Tagadu, was present. Kindly recall to your lordship's memory, even in the application which came to be filed under section 73 of the CRPC for the purpose of issuance of a non-bailable warrant against the petitioner, they would even make a mention of the investigator having recorded the statement of Shivananda Tagadu. I also drew your lordship's kind attention to the statements of Manoj Aradhya, in which statement your lordship would find that Shivananda Tagadu was there on that day, at that point of time, or till such time these 2 ladies left the place.
Because they are from the same place.
What?
They are of the same.
Yes,
place.
my lord. Who? Shivananda Tagadu, my lord? No. He is complainant and the petitioner before the lordship are from the same place.
Oh, complainant.
Complainant and the petitioner are from this. That is her statement. I know him so well, and but your lordship may recall to your lordship's memory, they ought to have placed in the fitness of in fairness. That is a fair investigation. The statement of Shivananda Tagadu.
No, his statement is recorded, is what you say, which is not a part of the charge sheet.
He is not even cited as a witness to the prosecution. Well, certainly it is open to your lordship to secure the records, the case file, but in the case file or in the case diary, as amended, well, under section 172, 2, if I am right, my lord, the statement which the investigator would have recorded of the witnesses would be enclosed to the case file. You should find a place. Probably, your lordship, my request to your lordship is secure the record of the case. Examine it. Whether, what does he say? That Shivananda Tagadur. Shivananda Tagadur is there. Aradhya is there. Manoj is there. How many witnesses are there? But as far as checking is concerned also, it is 45. 30. Yes. What is the statement of Anandaradhya, which your lordship would get at page, commencing from page 24 of my compilation. He was the one who was present throughout.
Sir, if you permit, 2:30 mood matters on 15 ಇದೆ. I'll finish that and get back to this.
Please.
Because this will take some more time. ಮತ್ತೆ hand delivery ಇರುತ್ತೆ ಕಷ್ಟ ಆಗ್ಬಿಡುತ್ತೆ.
Please.
Wait a minute. ಇದೆಲ್ಲ ಇಲ್ಲೇ ಇರುತ್ತೆ. ರೆಡಿ ಆಗುತ್ತೆ. ಇದಿರಲಿ. ರೆಡಿ. ಎಸ್ ಕೊಡಿ.
matters list number 3, serial number 1, Prithviraj P. Kalmani.
ನೆನ್ನೆ ಒಂದು ಎಜುಕೇಶನ್ ನೆನ್ನೆ ಮಾಡಿದ್ನಲ್ಲ ಅದೆಲ್ಲ
pertaining to the examination.
Where is it? Yesterday's order. LLB. ಅದೇ ಜಾಬ್ ಓರಿಯೆಂಟೆಡ್ ಕೋರ್ಸ್.
Exam is held on 20th.
ಅಲ್ಲ ಜಾಬ್ ಓರಿಯೆಂಟೆಡ್ ಕೋರ್ಸ್ ನೆನ್ನೆ ಒಂದು ಮಾಡಿದೆ. ಯಾರು ಮಾಡಿ ನೀವು ಮಾಡಿದ್ರಿ? ಮಾಡಿ.
May permitted to take hand delivery.
Yes. 1 to 4 same order.
5, Sriharsha Nilopan.
Lord, the administrator has been appointed to the temple, my lord, without issuing any notice and contrary to section 25A because it's a trust, my lord. So
already appointed.
Point agide, but not
Not assumed charge.
Not assumed the charge. Lord, and this honorable court in the similar matter has
one HCGP term ಮುಗಿದೋಗಿದೆಯಾ? ಟರ್ಮ್ ಮುಗಿದೋಗಿದೆಯಾ?
ಇಲ್ಲ, ಅದು ಟ್ರಸ್ಟ್ ಅಲ್ಲಿ ಟರ್ಮ್ ಇರಲ್ಲ. There is no term, Lord. There is 25A excludes management. Yes. 1,
2, 3, all respondents. The learned counsel for the petitioner, taking this court to the documents appended to the petition, seeks to demonstrate that the act of the state in seeking to appoint an administrator runs counter to section 25A of the Religious and Charitable Endowments Act. The notice ಕೊಟ್ಟಿಲ್ವಾ?
Without notice.
Inasmuch as the action is taken without issuing any notice, in that light, there shall be an interim order of stay only if the administrator has not assumed charge as on today.
Please.
Bill number 6, RA
Lord,
Assembly.
may I seek hand delivery?
ಎಲ್ಲ hand delivery ಇದೆ.
Number 1 to 4. Permitted to take hand delivery.
Already granted.
Respond number 2 minutes.
ಯಾರು? ಬೆಟೂರ್ ಮಠ್. ನೆನ್ನೆ ಯಾವ್ದು ಮಾಡಿ? KL ಪಾಟೀಲ್. ಕರೆಕ್ಟ್. ನೆನ್ನೆ ಅದೇ ಮಾಡಿ. ನೀವು ಮಾಡಿದಿರಲ್ಲ ಮೇಡಮ್?
Similar order was passed by this honorable court in another.
This is Lokayukta matter.
My lordship, the impugned judgment was passed. And as on this day, my lordship, hearing on sentence is not passed. And he was taken to custody on the very same day that is on 8th.
Yes, the same order.
Yes.
Anil Kale. Kale, you should tell the court, convict ಮಾಡ್ಬಿಟ್ರೆ ಆಗಲ್ಲ. Sentence is separate.
Yes, my lord.
Convict ಮಾಡ್ಬಿಟ್ಟು sentence pronounce ಮಾಡಲ್ಲ, already arrested. What is all this? Same. Yes, basics of law ಗೊತ್ತಿಲ್ಲ. Conviction pass ಮಾಡೋದು, police arrested. Yes, same order. Take this petition along with this same order.
Request for hand delivery.
What is it?
7, Shivraj P. Mudho.
Appear for the petition. But no,
Caveat, Sadiq Kodwala.
they are not filed caveat, but it is earlier, my lord, that writ petition was disposed of. But I wanted to serve the copy, they refused to receive the copy, that they have not filed caveat in.
Urgency ಏನು?
Urgency, my lord, no confidence motion, my lord.
When?
My lord, PDO participated.
ಯಾವತ್ತಿದೆ?
One date is 1/2 ಇದೆ, but it is
1/2
covered.
ಇದೆ. Monday.
Covered, my lord.
Monday before the regular court. Yes.
Like it is covered by.
List on Monday before the regular court. 1/2 ತಾನೇ ಇರೋದು. Yes. Next.
Number 8, C.R. Raymond.
Morning matter.
Morning,
For
same.
announcement of
That's my
result.
comments.
ಇದು same covered.
Same. Serial number 59 under.
ವಿಶಾಲ್ ಗಾಗಿ.
Serial number 59 matter.
59 same order.
Next matter also same.
Next matter 9 same.
Yes.
10 ದಯಾನಂದ್ ಬಂಡಿ. ಇದು ದೊಡ್ಡ ನಿವೇದಿತ ಮೇಡಮ್. ಇದು 7, 8, 7 ಅಲ್ಲ 7, 8 and 9 ಬೆಳಗ್ಗೆ ವಿಶಾಲ್ಗೆ ಸುಮಾರು ಮ್ಯಾಟರ್ಸ್ ವಿಡ್ರಾ ಮಾಡಿ ಸೇಮ್ ಆರ್ಡರ್ ಕವರ್ಡ್ ಜಸ್ಟಿಸ್ ಶ್ಯಾಮ್ ಪ್ರಸಾದ್ ಅವರು.
My lord, in this case, the court which has neither passed a decree nor the court which has passed a decree has transferred it to this court without the jurisdiction, my lord, in the dealing with the money recovery suit, my lord, has attached the property without inquiring into what extent of a property can satisfy the decree.
Send notice to the respondents returnable by the 12th of February. The petitioner is at liberty to serve the counsel, apart from taking out steps, the petitioner is at liberty to serve the counsel who represented the respondents 1 and 2 before any proceeding. In any proceeding before the concerned courts, there shall be an interim order of stay spread for to the next. Next.
My lord, may I seek a hand delivery? Tomorrow, the execution warrant would be issued.
Pudi sir, memo. ಪಾಕೆಟ್ ಅಲ್ಲಿ ಇಟ್ಕೊಂಡು ಅದು ಫೋಲ್ಡ್ ಮಾಡ್ಕೊಂಡು ಏನಂತ ಸರ್ ಈ ಪ್ರಾಕ್ಟೀಸ್ ಎಲ್ಲ ನಿಲ್ಲಿಸ್ಬೇಕು. ಫೈಲಲ್ಲಿ ಇಟ್ಕೊಳಕ್ಕೆ ಏನಂತ
ಇಲ್ಲ, ಅದು ಈಗ ತಂದು ಕೊಟ್ಟರು, ಅದಕ್ಕೆ ಅದನ್ನ ಫೈಲ್ ಇರಲಿಲ್ಲ. Tomorrow, possession warrant would be issued tomorrow. That's why. Much obliged.
Next. Number
7, Sachin.
same Sachin.
My lord, in this matter, my lord, the respondent number 6 election is conducted, my lord, and which is held on file 5/1/2025, my lord. My lord, in this election, my lord, the returning officer has issued the eligible voters list, my lord, as per annexure B, my lord. In that, my lord, the one person is deceased, my lord. My lord, and
ಎಲ್ಲ election petition ಗೆ Kalburgi bench has reversed my order, which I entertained like this.
And my lord, same person is casted the vote, my lord.
ಎಲ್ಲ subject matter of election petition.
Which is, I have produced the death certificate of the.
ಎಲ್ಲ election petition.
And
ಆಗೋಗಿದೆಯಲ್ಲ election ಈಗ?
Yes, my lord.
No.
And
file an election petition with all the grounds that you have urged now.
if the election petition is filed, my lord, it will take long time, my lord, for
No, ಅದಕ್ಕೆ
disposing
writ
the.
petition is the remedy.
My lord. Because the returning officer has, my lord, annexure D, my lord.
File an election petition, all the grounds. The petitioner is before this court, calling in question the result of an election. The counsel for the petitioner, Sachin C. Angadi, projects plethora of circumstances which would depict that the persons who are no more, persons who are dead are made to cast their votes, or
They have cast the vote, my lord.
so on and so forth. All these matters would become a subject matter of an election petition, since the election is already over and the results are already declared.
The result is not yet
All
declared.
elections are already over. Since the elections are over, petitioner is reserved liberty to approach the appropriate forum/fora, seeking, venting out his grievance. The petition is disposed, reserving such liberty to urge all the contentions before the concerned court. Yes, next.
My lord, at least the time limits may be fixed, my lord. If
Limit is statutorily done, sir. You have to go.
My lord,
How election ಆಗಿರುತ್ತೆ?
5th is the election is conducted, my lord.
20 days time ಇದೆಯಲ್ಲ.
If a petitioner is filed the election petition before the appropriate forum, my lord, within 30 days, my lord,
That
to
is
dispose.
statutorily fixed. I will not extend it. Yes, next.
Bill number 12, Ramchandra Imani.
Challenging the MA order, my lords, in this, my lords,
Monday barley.
my lords, they are trying to construct, my lords,
Trying
construction.
to construct, they'll finish construction on Saturday and Sunday.
My lords, the construction is going on. I have attached the photograph.
Monday or Wednesday, my lords.
ಯಾಕೆ ಅಲ್ಲಿವರೆಗೆ ಮುಗಿಸ್ಬಿಡ್ತೀರಾ?
No, my lord, senior is not here, my lords. So
Senior is not there.
please, my lords.
Then we will stop construction.
Please, no, my lords.
Yes. ಅವ್ರಿಗೂ ಬೇಕಾಗಿರೋದು ಅದೇ.
No, no, my lords.
Stop
Please.
construction.
No, my lords.
Yes, list on Monday in the fresh matters.
My lords,
Please, my lords.
Spoke where the property be maintained by the parties till the next date of hearing.
Monday, some senior function, my lord.
Interim ಅಂತ ತಗೋಬೇಕಾದ್ರೆ ಅದಕ್ಕೂ ರೆಡಿ ಇರಬೇಕು. ಎಸ್ ಮಂಡೇ.
Please, my lords.
Vinayak.
ಇಬ್ರು ಸೀನಿಯರ್ಗೂ ಒಂದೇ ಫಂಕ್ಷನ್ ಇದೆಯಾ ಅಥವಾ ಇಬ್ರು ಸೀನಿಯರ್ ಒಬ್ರೇನಾ?
My lords.
ಇಲ್ಲಲ್ಲ.
Senior.
Bill number 13.
Right to vote, my lord.
ಏನ್ ಓಟಾ? ವೋಟ್ ಆರ್ಡರ್. ಇನ್ನು ಎಷ್ಟಿದೆ ಎಲ್ಲ ಕೊಟ್ಬಿಡಿ.
ಅಲ್ಲ, ಲಿಸ್ಟ್ ಇದೆ, ಲಿಸ್ಟ್ ಕೊಟ್ಟಿಲ್ಲ.
Same, sir.
ಎಲ್ಲ ಸೇಮಾ?
Same.
ಅಂಡ್ ಡೆಲಿವರಿ ಬೇಡವಾ? ಕೊಡಿ.
Bill number 16, Manjunath Karigandanavar.
ಅದು ಅಷ್ಟೇ.
Same.
ಸೇಮ್. ನೀವು ಹೊರಡಿ ಮೇಡಮ್. ಹ್ಯಾಂಡ್ ಡೆಲಿವರಿ ಮಾಡ್ಕೊಳ್ಳಿ. ಮೇಡಮ್, ನಾನು ಅದು ಹೇರ್ ಮಾಡ್ತಾ ಇರ್ತೀನಿ. ಯಾರು ಬರೋದು ಬೇಡ. ನಾನು ಬೇಕಾದಾಗ ಹೇಳಿ ಕಳಿಸ್ತೀನಿ. ನೀವು ಹೊರಡಿ. ವೇಟ್ ಮಾಡುತ್ತೆ.
My lord, one submission.
Yes, sir.
That serial number 18 and with respect to that daughter of minister, my lord, that voting, this. Preliminary voting.
My lord, kindly pass out.
Not a final vote.
Kindly pass out. Senior will engage in other court.
ಆಯ್ತು, ಕರ್ಕೊಂಬನ್ನಿ. ತೊಂದರೆ.
Kindly pass out.
Very preliminary, I will not interfere.
Next year, preliminary vote. Garadu prati ante.
ಸೀನಿಯರ್ ಹೇಳಿ. ಪ್ರಿಲಿಮಿನರಿ ಒಪಿನಿಯನ್ ಡಿಸ್ಮಿಸ್ ಮಾಡ್ತಾರೆ.
ಇಲ್ಲ ಮೇಲೆ ಬರ್ತಾರೆ.
ಸಾರಿ ಮೈ ಲಾರ್ಡ್.
Sorry.
2:30 ಮ್ಯಾಟರ್ ಐ ಮೂಡ್ ಮೈ ಲಾರ್ಡ್, ಬಟ್
ಆಯ್ತು, ಬಂದಾಯ್ತಲ್ಲ.
ಇಲ್ಲ ಬಂದಿಲ್ಲ ಸ್ವಾಮಿ.
ಬರದೇ ಇದ್ರೆ ಐ ಆಮ್ ಆಲ್ಸೋ ಸಾರಿ ಸರ್.
ಇಲ್ಲ ಸರ್, ರಾಜಶೇಖರ್ ಬಿ ಹೇಳಿ. ಸರ್ವಿಸ್ ನಾಟ್ ಕಾಲ್ಡ್ ಔಟ್ ಮೈ ಲಾರ್ಡ್, ದಟ್ಸ್ ಐ waiting.
Called out.
ಹೌದು
ಯಾಕೆ madam?
ಐ ಆಮ್ ವೇಟಿಂಗ್ ಫಾರ್ ಯು. ದಟ್ಸ್
He's waiting, you have not called out his case.
ರಾಜಶೇಖರ್ ಬಿ ಹೇಳಿ. Not it sent, my lord. Morning today I moved, my lord. 2:30 I mentioned I moved and
ನಾಟ್ ಕಾಲ್ಡ್ ಔಟ್ ಅಂದ್ರಿ?
ಅದು ಬಂದಿಲ್ಲ ಸ್ವಾಮಿ, ಲಿಸ್ಟ್ ನಲ್ಲಿ ಇಲ್ಲ.
ಬಂದ್ರೆ ತಾನೇ ಕಾಲ್ ಔಟ್ ಮಾಡೋದವರು. ಬರ್ಲಿ. ನೀವು ಅರ್ಜೆಂಟ್ ಹೋಗ್ಬೇಕಾ?
Waiting, my lord.
ಫ್ಲೈಟ್ ಇದೆಯಾ?
Service matter, my lord.
ಸರ್ವಿಸ್ ಮ್ಯಾಟರ್. ಯಾವ ಮ್ಯಾಟರ್?
PDO, my lord, that he was transferred, my lord. Handicapped. Yeah, please.
ನಿಮ್ ಫೈಲ್ ಕೊಡಿ.
Relevant page number 29, my lord. Recently notification issued.
ಯಾವತ್ತು ಟ್ರಾನ್ಸ್ಫರ್ ಆಗಿದ್ದು?
Transfer, my lord, 13/12/2024, my lords. Next year,
ಮತ್ತೆ ಟ್ರಾನ್ಸ್ಫರ್ ಮಾಡಿದಾರೆ ಈಗ?
ಹೌದು, ಮತ್ತೆ ಟ್ರಾನ್ಸ್ಫರ್. Within 15 days again he was transferred. I draw the attention of my lords at page number 29, relevant page. Recently notification issued without prior permission of the high authority, my lord.
ವಾರಕ್ಕೊಂದು ಟ್ರಾನ್ಸ್ಫರ್ ಮಾಡ್ತಾ ಇದೀರಾ ಇಲ್ಲಿ?
ಕೊಟ್ಟಿದ್ದೀನಿ ಮೇಡಮ್.
ಮೇಡಮ್, ಲಿಸ್ಟ್ ಆಗದೇನೆ ಎಂಟ್ರಿ ಮಾಡಿ ಕೊಡೋಕ್ಕಾಗಲ್ಲ. ಲಿಸ್ಟ್ ಕೇಳಿ ಮೂವ್ ಮಾಡಿದ್ದೀರಾ?
ಮೂವ್ ಮಾಡಿದ್ದೀನಿ ಸ್ವಾಮಿ, ಮಾರ್ನಿಂಗ್ ಮೂವ್ ಮಾಡಿದ್ದೀನಿ. ಐ ವಾಸ್ ಕಂಪ್ಲೈಂಟ್ ಎವ್ರಿಥಿಂಗ್. ದೇ ಆರ್ ಅಶ್ಯೂರ್ಡ್ ಟು ಮಿ ದಟ್ ದೇ ಸೆಂಟ್ ದ ಫೈಲ್.
ತರ್ಸಿ.
PDO.
ಕೇಟಿ. ಐ ವಿಲ್ ನಾಟ್ ಡ್ರೈವ್ ಎನಿಬಡಿ ಟು KIT. ನಿಮ್ದಲ್ಲ, ಅದು ಏನೋ PDO ಅದು ಹೊಡೆದಾಡ್ತಾ ಇದ್ದಾರೆ ತಾಳಿ.
I draw page number 29, next year G, my lord.
ಆಯ್ತು, ಒಂದ್ ನಿಮಿಷ. ಫೈಲರ್ ಬರ್ಬೇಕಲ್ಲ. ಲಿಸ್ಟೇ ಆಗ್ಲಿಲ್ಲ, ಸ್ಟೇ ಕೊಟ್ರು ಅಂತಾರ ಆಮೇಲೆ. ಬರುತ್ತಲ್ವಾ? ಬರುತ್ತೆ. ನಿಮ್ದೇನ್ ಸರ್? ನಿಮ್ದು ಫೈಲ್ ಬಂದಿಲ್ವಾ?
ಹ್ಯಾಂಡ್ ಡೆಲಿವರಿ serial number 2.
ಯಾವ್ದು ಜಡ್ಮೆಂಟ್ ಗಂಗದ? PDO should go before the KIT ಅಂತ. ವೆರಿ ಗುಡ್. ಎಸ್. ಆಮೇಲೆ Panchayat will not come under the KATs. Karnataka Municipal Administrative Service idre matra KAT, KMAS. Those officers will go before the KAT and not every case. Panchayat Development Officer is ille. Yes. KAT ಗೆ ಹೋಗ್ಬಿಡಿ. Yes. Petitioner is before this court. Calling in question an order of transfer dated. Yan date?
13/12/2025, Annex D, my lord.
13/12/2024, by which he is sought to be transferred within 15 days of earlier order of transfer, which was on 13/12/2024. Adena?
No, my lord.
Allala, which was earlier on. Sir, you are placed under suspension.
No, suspension,
Ah.
suspension, my lord. But my lord, suspension within fractions of 15 days, earlier, my lord, suspension
Revoke madidra?
suspension revoke ಮಾಡಿದ್ರು. Again, he was revoke the suspension.
Suspension revoke ಮಾಡಿ ಅದೇ
ಅದೇ ಜಾಗಕ್ಕೆ ಹಾಕಿದ್ರು. Within 16 days, transfer to the original place, my lords.
Original place?
Means, my lord, where suspended place, my lord, that is Nandihalli, Pattan Panchayat, Nandihalli.
ನೀವು ಫಸ್ಟ್ ಎಲ್ಲಿ ಕೆಲಸ ಮಾಡ್ತಾ ಇದ್ರಿ?
Nandihalli ಗ್ರಾಮ ಪಂಚಾಯತ್, my lord.
ಅಲ್ಲಿ ಸಸ್ಪೆಂಡ್ ಆದ್ರಿ?
ಹೌದು ಸ್ವಾಮಿ, ಹೌದು.
ಸಸ್ಪೆನ್ಷನ್ ರಿವೋಕ್ ಮಾಡಿದ್ರು?
ನಂದಿ ಬೇವೂರಿಗೆ ಟ್ರಾನ್ಸ್ಫರ್ ಮಾಡಿದ್ರು.
ಸಸ್ಪೆನ್ಷನ್ ರಿವೋಕ್ ಮಾಡಿ ಎಲ್ಲಿಗೆ ಹಾಕಿದ್ರು?
ನಂದಿ ಬೇವೂರು.
ಅದಾದ್ಮೇಲೆ ಎಲ್ಲಿಗೆ ಹಾಕಿದ್ರು?
ಅದಾದ್ಮೇಲೆ ಮತ್ತೆ ನಂದಿಹಳ್ಳಿಗೆ ಟ್ರಾನ್ಸ್ಫರ್ ಮಾಡಿದ್ರು.
ಒರಿಜಿನಲ್ ಪ್ಲೇಸ್?
ಹೌದು, ಒರಿಜಿನಲ್.
ಎಂಜಾಯ್ ದಟ್. ತೊಂದ್ರೆ
ಓನ್ಲಿ 16 days ಒಳಗೆ ಮೋರೆವರ್
ಇಲ್ಲಿ ಬೆಟರ್
ಹ್ಯಾಂಡಿಕ್ರಾಫ್ಟ್.
ಹ್ಯಾಂಡಿಕ್ಯಾಪ್?
ಹೌದು. Is not able to, I produce the documents.
Not able to what?
ಹೌದು, ಕಾಲು ಕಟ್ ಆಗಿದೆ ಸ್ವಾಮಿ.
ಇಲ್ಲ, ಅದು ಆಲ್ ರೈಟ್. ಈಗ ವಾಪಸ್ ನಿಮ್ಮೂರು ಯಾವ್ದು?
ನಮ್ಮೂರು ನಂದಿಹಳ್ಳಿ.
ಅಲ್ಲಿಗೆ ಊರಿಗೆ ಕಳಿಸಿ.
ಬೇಡ, ಅಲ್ಲಿ ಯಾಕಂದ್ರೆ ಸ್ವಾಮಿ ಅಲ್ಲೇ ನಾನು ಸಸ್ಪೆಂಡ್ ಮಾಡಿದ್ದಾರೆ, ಅಲ್ಲೇ ಡ್ಯೂಟಿ ಮಾಡೋದು. ಐ ಆಮ್ ನಾಟ್ ಕಂಫರ್ಟೇಬಲ್.
ಯು ಆರ್ ನಾಟ್ ಕಂಫರ್ಟೇಬಲ್.
ಇಟ್ ಇಸ್ ಗ್ರೀವೆನ್ಸ್.
ಇಲ್ಲ, ಇವ್ರಿಗೆಲ್ಲ ಎಲ್ಲೆಲ್ಲಿ ಕಂಫರ್ಟ್ ಇದೆ
ಅದು minor irregularity is there, might already settled, my lord. Now recently notification issued, the executive officer of Jilla Panchayat as well as Tantluk Panchayat without prior permission, my lord, have no power to transfer, my lord. Recent notification of the respondent number 1, I produce an X here, J my lord, page number 29, my lord. Moreover, handicapped, my lord, that's the.
Yes. So Leonard HCGP is directed to accept notice for respondent 1, 2, 3, 4. Emergent notice to 5th respondent. Charge ತಗೊಂಡಿಲ್ವಾ ಅವರು?
ಇಲ್ಲ, ಇನ್ನ ಚಾರ್ಜ್ ತಗೊಂಡಿಲ್ಲ.
There shall be an interim order of stay spread for only if the 5th respondent has not taken charge in accordance with law.
Hand delivery.
Handicap?
Interim order, hand delivery.
Hand delivery. Yes. ಬಂತ? ತರ್ಸ್ಬಿಡಿ ಮೇಡಮ್. ನಿವೇದಿತ ಮೇಡಮ್, ನೀವು ಈಗ ಮಾತಾಡಿ, ಒಂದು ನಿಮಿಷ ರಿಸ್ಕ್ ಬೇಡ, ಆಯ್ತಲ್ಲ? ಎಲ್ಲ ಎಸ್ ಸರ್. ನಾಗೇಂದ್ರ ನಾಯ್ಕ, ಅದ್ರಲ್ಲಿ ಏನಿಲ್ಲ. ಕರಡು ಪತ್ರ ಅಂತ
ಅಲ್ಲ, ಅವರು
ಕರಡು ವೋಟರ್ ಐ ವಿಲ್ ನಾಟ್ ಇಂಟರ್ಫಿಯರ್.
ಅಲ್ಲ, ನಾನು
ಫೈಲ್ ಯುವರ್ ಅಬ್ಜೆಕ್ಷನ್ಸ್, ದೇ ವಿಲ್ ಕನ್ಸಿಡರ್.
ಹಾಕಿದ್ದೀನಿ, ಪೊಲೀಸ್ ಕಂಪ್ಲೇಂಟ್ ಕೊಟ್ಟಿದ್ದೀನಿ.
ನೀವು ಏನಾರು ಮಾಡಿ, ಇಟ್ ಇಸ್ ಪ್ರಾವಿಷನಲ್ ವೋಟರ್ಸ್ ಲಿಸ್ಟ್, ಐ ವಿಲ್ ನಾಟ್ ಇಂಟರ್ಫಿಯರ್.
ಅಲ್ಲ, ನಾನು ಒಂದು ನಿಮಿಷ ತೋರಿಸ್ಬಿಡ್ತೀನಿ, ಆಮೇಲೆ
ಪ್ರಾವಿಷನಲ್ ತೋರಿಸಿದ್ಲಿ ಏನ್ ಬಂತು?
ಅಲ್ಲ,
ಪ್ರಾವಿಷನಲ್ ಹೌದಾ ಇಲ್ವಾ? ಫೈಲ್ಡ್ ಅಬ್ಜೆಕ್ಷನ್ಸ್.
ಪ್ರಾವಿಷನಲ್ ಹೌದು, ನಾನು ಅಬ್ಜೆಕ್ಷನ್ ಹಾಕಿದ್ದೀನಿ. ಮೈ ಓನ್ಲಿ ರಿಕ್ವೆಸ್ಟ್ ಇಸ್ ದಿ ಬ್ಯಾಂಕ್ ಸಾಫ್ಟ್ವೇರ್ ದೇ ಹ್ಯಾವ್.
ಅರೆ ಆಯ್ತು ಸರ್, ನಿಮ್ ಅಬ್ಜೆಕ್ಷನ್
ಕನ್ಸಿಡರ್ ಮಾಡಿ ಫೈನಲ್ ಲಿಸ್ಟ್ ಮಾಡಿ ಅಂತ ಹೇಳಿ.
ಪೊಲೀಸ್ ಕಂಪ್ಲೇಂಟ್ ಏನ್ ಕೊಟ್ಟಿದ್ರೆ ಪರ್ಸೂ ಮಾಡಿ, ಸಿಂಪಲ್.
Election officer, let him
The petitioner is before this court seeking the following prayer. The learned additional advocate General Gangadhar, taking this court through the documents produced by the petitioner, would seek to demonstrate that what is called in question is a provisional voters list to which the petitioner has filed his objections. If that be so, it is for the authorities to consider the objections and pass necessary orders in accordance with law. There can be no question of a challenge to a provisional voters list. Provisional voters list. Writ petition is disposed as premature, reserving liberty to the petitioner to avail of such remedy as available in law at the appropriate time, before the appropriate fora, at the appropriate stage. Yes.
Before finalizing the final list.
Appropriate stage.
One time limit. ಇಲ್ಲ ಅಂದ್ರೆ ಏನ್ ಮಾಡ್ತಾರೆ
ಮಾಡ್ತಾರ ಅವರು?
Reason is.
ಅರೆ ಬೆಳಗ್ಗೆ ಇವ್ರ ಅಪ್ರಹೆನ್ಷನ್ ವಾಸ್ ನಾಳೆನೆ ಮಾಡ್ಬಿಡ್ತಾರೆ ಅಂತ.
ಅಲ್ಲ ನಾಳೆನೆ ಮಾಡ್ತಾರೆ.
ಮಾಡ್ಲಿ ಬಿಡಿ, ಫೈನಲ್ ವೋಟರ್ಸ್ ಲಿಸ್ಟ್ ಮಾಡಿದ್ರೆ ಚಾಲೆಂಜ್ ಮಾಡಿ ಅಷ್ಟೇ. ಎಸ್ ಮೇಡಮ್ ಗೊತ್ತಾಯ್ತಲ್ಲ, ಅಪ್ರೋಪ್ರಿಯೇಟ್. ಎಸ್ ಇವ್ರನ್ನ ಕಳಿಸ್ಬೋದಾ? ಕಳಿಸ್ಬೋದ?
Serial number 18.
ಎಸ್ ಸರ್. ಅದು ಸಮ್ ಸ್ಟೂಡೆಂಟ್ಸ್ ಎಕ್ಸಾಮಿನೇಷನ್ ನಾಳೆ, ಅದಕ್ಕೆ ಅರ್ಜೆಂಟ್. ಅದು ಫೈಲ್ ಲಿಸ್ಟ್ ಮಾಡಿಸಿ, ಅದು ಎಂಟ್ರಿ ಮಾಡಿಕೊಟ್ಟು ಅಲ್ಲ. ಎಸ್ ಸರ್.
ಆನಂದ ಆರಾಧ್ಯ ಎಲ್ಲಿ ಮಾಯ ಆಗ್ಬಿಡುತ್ತೆ ಒಂದು ನೋಡಿದ್ರ. ಜಸ್ಟ್ ಟೇಕಿಂಗ್ ಯುವರ್ ಲಾರ್ಡ್ಶಿಪ್ ಟು ದಿ ಸ್ಟೇಟ್ಮೆಂಟ್ ಆಫ್ ಆನಂದಾರಾಧ್ಯ.
ಅದು ಓದಿದಿರಲ್ಲ?
ಇಲ್ಲ, ಶುರು ಮಾಡಿದೆ ಅಷ್ಟರಲ್ಲಿ. 30 page 30. 30.
Yes, sir.
May I just request your lordship to kindly go to.
No, he would speak about the presence of Tavador.
Adalla, not only he would speak about the presence of Tagador, Shivananda Tagador, but he would also say that they were sitting in the drawing room, nothing happened, they left the place. Witness after witness.
Allah, ಅದನ್ನೆಲ್ಲ first ನೇ ಓದು.
ಇಲ್ಲ, ಇದರಲ್ಲಿ why I am taking your lordship again. Kindly go to page 30. Well, it commences at page 24.
Last. Yes, 30.
Yes, madam?
Yes.
It commences at page 24. Kindly go to page 30.
Yes.
And question number 11.
10 and 11.
11 only. 11 only. 2/2/24 ಯಡಿಯೂರಪ್ಪನವರ ಮನೆಗೆ ಬಂದು ಹೋಗರು, ನೀವು ಎಲ್ಲಿದ್ದೀರಿ, ಅವರು ಮಾತನಾಡಿ ನೀವು ನೋಡಿದ್ದೀರಾ. 2/2/24 ಮಮತಾ ಸಿಂಗ್ ಮತ್ತು ಅವರ ಮಗಳು ಮೊದಲ ಬಾರಿ ಬಂದಾಗ ಶಿವಾನಂದ ತಗಡೂರು ಜೊತೆಲಿ ಬಂದಿರುತ್ತಾರೆ. ಎರಡನೇ ಬಾರಿ ಅದೇ ದಿನ ಬಂದಾಗ ತಾಯಿ ಮಗಳಷ್ಟೇ ಬಂದಿರುತ್ತಾರೆ. ಈ ಎರಡು ಸಂದರ್ಭದಲ್ಲಿ ನಾನು ಸಾಹೇಬರ ಮತ್ತು ತಾಯಿ ಮಗಳು ಮತ್ತು ಶಿವಾನಂದ ತಗಡೂರು ಇವರೆಲ್ಲರ ಕಣ್ಣೆಳತಿಯ ದೂರದಲ್ಲಿ ಇದ್ದನು. ಅವರು ಮಾತನಾಡುವುದು ಅಸ್ಪಷ್ಟವಾಗಿ ಕೇಳಿಸುತ್ತಾ ಇತ್ತು. ಮಮತಾ ಸಿಂಗ್ ಅವರ ಮಗಳ ಮೇಲೆ ಅವರ ಸಂಬಂಧಿಕರು ಅತ್ಯಾಚಾರ ಮಾಡಿದ ಬಗ್ಗೆ ಮತ್ತು ಟ್ರೇಡಿಂಗ್ ನಲ್ಲಿ 5,000 ಕೋಟಿ ರು ಹಣ ಬರುವ ಬಗ್ಗೆ ಮಾತನಾಡುತ್ತಾ SIT ಬೇಕಾದ ಕೇಳುತ್ತಾ ನನ್ನ ಮಗಳ ಪರಿಸ್ಥಿತಿ, ನನ್ನ ಮಗಳನ್ನು ನೋಡಿ ಎಂದು ಪದೇ ಪದೇ ಹೇಳುತ್ತಾ ಇದ್ದರು. ನೆಕ್ಸ್ಟ್ ಸೆಂಟೆನ್ಸ್ ಬಿಕಮ್ಸ್ ವೆರಿ ವೆರಿ ಇಂಪಾರ್ಟೆಂಟ್. ನನಗೆ 9 ವರ್ಷಗಳಿಂದಲೂ ಸಹ ನ್ಯಾಯ ದಕ್ಕಿಲ್ಲ. ಎಲ್ಲರ ಮನೆ ಬಾಗಿಲಿಗೆ ಅಲಿಯುತ್ತಾ ಇದ್ದೇನೆ. ಬೇಕಾದರೆ ನನ್ನ ಮಗಳ ವಿಷಯವನ್ನು ಚೆಕ್ ಮಾಡಿಸಿಕೊಳ್ಳಿ ಎಂದು ಪದೇ ಪದೇ ಹೇಳುತ್ತಾ ಇದ್ದರು.
ಚೆಕ್ ಅಂದ್ರೆ ಇದು ಅಂತ ನೀವು ಹೇಳ್ತಿರೋದು?
ಅದು ನಾನಲ್ಲ ಹೇಳ್ತಾ ಇರೋದು.
ಅಲ್ಲ, ಎವಿಡೆನ್ಸ್ ಅಲ್ಲ, ಪ್ರಾಸಿಕ್ಯೂಷನ್ ವಿಟ್ನೆಸ್
ಅಲ್ಲ, ಒಂದ್ಸರಿ ಅಲ್ಲ, ಪದೇ ಪದೇ ಚೆಕ್ ಮಾಡಿಕೊಳ್ಳಿ ಅಂತ ಹೇಳ್ತಾ ಇದ್ರು ಅಂತ ಅಂದ್ಬಿಟ್ಟು. ದ್ಯಾಟ್ ಇಸ್ ದಿ ಎವಿಡೆನ್ಸ್. ನಾಟ್ ದಟ್ ಮೇಲೆ ಐ ವುಡ್ ಸೇ ನಾನು ಚೆಕ್ ಮಾಡಿದೆ ಇವ್ರದ್ದು ಹೇಳ್ತಾ ಇದ್ದರು. ಸಾಹೇಬರು ಸಹ ನಿನ್ನ ಮಗಳು ನನ್ನ ಮೊಮ್ಮಗಳ ಇದ್ದ ಹಾಗೆ ಚೆನ್ನಾಗಿ ಓದಿಸು, ಸಹಾಯ ಮಾಡುತ್ತೇನೆ ಎಂದು ಹೇಳಿದ್ದನ್ನು ಕೇಳಿಕೊಂಡಿದ್ದೇನೆ. ದಿಸ್ ವರ್ಚುಯಲಿ ಕರಾಬೊರೇಟ್ಸ್
ವಿತ್ ದಿ ಚೆಕಿಂಗ್ ಡನ್.
ಎಸ್, ಯಾತಕ್ಕೆ ಅಂತ ಅಂದ್ಬಿಟ್ಟು ಅಂತ ಅವ್ರನ್ನ ಐ ಡಿಡ್ ನಾಟ್ ಆಸ್ಕ್ ದಿ ಇನ್ವೆಸ್ಟಿಗೇಟರ್ ಟು ಕ್ವಶನ್ ಮೀ ದಟ್ ಕ್ವಶನ್ ಏನಂತ. He would, if at all, my lord, if that answer is not palatable to the case of the prosecution, but they have invited the OD on their head by putting that question to me and eliciting that answer from me, because that forms part of the record of the case as evidence in the case. But this would answer the checking. ಇದರಲ್ಲೂ ಇದೆ, ಅದರಲ್ಲೂ ಇದೆ. That would be better. But ಅದು ಏನು ಒಂದ್ಸರಿ ಅಲ್ಲ, ಪದೇ ಪದೇ ಹೇಳ್ತಾ ಇದ್ಲು ಅಂತ. ಚೆಕ್ ಮಾಡಿ ಬೇಕಾದ್ರೆ ನೀವೇ ಚೆಕ್ ಮಾಡಿ ಅಂತ ಪದೇ ಅದನ್ನ ಹೇಳ್ತಾ ಇದ್ರು ಅಂತ ಅಂದ್ಬಿಟ್ಟು.
So according to you, the mother indicated that he should check about the case. And the petitioner has checked about the case.
And nothing more and nothing less would be my
This is the check.
This is the check. That would answer, my lord, the doubt, if any, that has been created. That too, my lord, when the investigator would put some questionnaires and elicits the answer in the recorded version of 2/2/2024, it is said that you have made a check. What is that check you have made? ಅಂತ ಕೇಳ್ತಾರೆ ಅದನ್ನ. ಪ್ರಶ್ನೆ ಅದೇ. Question number 30 and 31 that is put to the petitioner is the same in relation to that.
Yes.
My lord, the third submission which my learned friend made is with regard to, my lord, according to me, it looks absurd. It is so for this reason. Number one, see, subsequent to the death of this first informant in the case, you have made the first informant as a party to the proceedings which would file later to her death. But I don't know. ನಮಗೇನು ಬಂದು ಹೇಳಿದ್ರೆ ಅವ್ರು ಸತ್ತೋಗಿದ್ದಾರೆ ಅಂತ.
ಅದು ಹೇಳಿಲ್ಲ ಅವರು. ಪ್ರೊಫೆಸರ್ ಸರ್ ಏನ್ ಹೇಳಿದ್ದು ಅಂದ್ರೆ, ದೇ ಹ್ಯಾವ್ ವೇಟೆಡ್ ಟಿಲ್ ದಿ ಡೇ ದಟ್ ಹ್ಯಾಪನ್ಸ್ and then petition is filed after the death ಅಂತ. The affidavit is signed 1 month prior to that, and it is filed later ಅಂತ. Not making a dead person ಅಂತ ಹೇಳಿ.
My lord, your lordship may take it from me.
Death you knew or did not
How
know.
far that would be in furtherance of an offence under section 8 or an offence under section 354A, other than to play to the gallery?
Added circumstance he was dead.
Other than to play to the gallery, so that, my lord, there will be some publication. My lord, how in furtherance of the offence that is said to have been committed, that submission should inure to the benefit of the prosecution. Otherwise, no. Did she tell me at any point of time that she is going to breathe her last on a particular date? No, it was not communicated to me. Nor the prosecution or the investigator communicated to me that she has breathed her last. I do not have a magic wand in my hand like a magician, like a PC Sarkar or a Gogia Pasha, my lord, that she is going to breathe her last. I am not a palmist or an astrologer also to imagine for myself that she is going to breathe her last. My lord, I honestly believed that she is there. Otherwise, I would not have made her a party. Illi, ಕೆಲವು ಸಾರಿ ಏನಾಗುತ್ತೆ
No, I think my learned friend is posing a question to himself which I did not put. My case is the petition is not verified by an affidavit. Yeah, I never attributed any kind of motives which my learned friend is now attributing to me. I am not the type to play to the gallery. Everyone knows who is in the gallery.
We know your fairness, sir.
You know.
It is not a negative compliment, sir.
Who is in the
It is not a
gallery?
negative compliment. It is a positive compliment to you.
Oh, no. I
You have
never.
sadly mistaken me.
I never played to the
Don't mistake
gallery.
me.
Sorry.
We know your elementary basic fairness very well.
It is a comment on me personally playing to the gallery. Sorry, I take serious exception. I never do it. I have never done it in the past.
No, sir. No, nobody believes that you do it, sir. So don't
Sir,
worry.
Sir, my comment on the affidavit and the petition was
Yes.
limited to the fact.
No,
This
I
is a
myself-
petition.
Sir, I myself clarified what was your intention in saying that. That's all.
Yeah, that's.
My lord, these would be the three submissions which Professor Kumar has made, if I am right, my lord, subject to submissions or ಮಾಡಿದ್ದು ಪುತ್ರ ಅಷ್ಟೇ ಮಾಡಿದ್ದು ಅಂತ ಕಾಣುತ್ತೆ. He did not invite my lord's kind attention to any one of the statements of these witnesses. Obviously, maybe for the reason, my lord, in his wisdom, he might have thought that it may not be necessary. It would not be in furtherance of his submissions. In the event of he inviting my lord's kind attention, that would certainly go against the case.
Now, the main submission made was relying on a judgment of the apex court that 161 statement cannot be relied on to quash.
But
You have
I have-
relied on several judgments.
I have
It is for me
invited
to
my lord's
consider now.
attention to the latest
No,
judgment.
that is why it is for me to consider those and pass.
My lord's attention
Now,
to
the learned Professor Sir has relied on
those things.
those judgments, all right. And I will consider both of them and then pass out.
But, now that your lordship is told, number one statement of the victim. Well, the first information report is nothing but the statement of the victim.
Yes.
In other words, my lord,
The information of the
she has
victim.
nothing else to say. She has
No,
nothing
it's the
else to say
information of the victim. That's
other than what the victim has said.
No,
In
it
other
can't.
words,
FIR only anything, nothing else can be added than
Added
what
to
the
that.
victim or whoever the first informant would say.
otherwise, one statement of the victim which is put into test by the investigator in the form of investigation. As against that, your lordship has the advantage of half a dozen statements of witnesses who were the ones said to have been present at the time of the offense. That is number one. Number two, my lord, the other day I invited my lord's kind attention to the learned trial judge would not only take cognizance of the offence under section 8 and 354 capital A, as well as the one which is made penal under section 204 and 214. Not only against the petitioner in this petition.
204, 214, 214.
214. Although straight away, my lord, I would
Concerning the other petitions.
concerning either your ಮೇಲೂ ಇದೆ.
It's a common order of cognizance.
ಅದನ್ನ ಅವ್ರ ಮೇಲೆ ತಗೊಂಡಿದ್ದರಿಂದ ಇವ್ರ ಮೇಲೆ ಬಂತು ಅದನ್ನ ಅಂತ ಅನ್ಬಿಟ್ಟು that is assuming everything is true. It would not constitute an offence under section 204 or under section 214. The person who is said to be guilty of that offence in the event of such an event having been happened, it is only the complainant and nobody else.
Now Sunil Bharati Mittal is repeated now by the apex. Ilva. Where is Sanjay Dutt? 2025 SEC online SC page 32.
Bail.
Sunil Bharati Mittal is now again reiterated.
It has been reiterated.
Sunil Bharati Mittal is reiterated with regard to cognizance.
Yes. Commencing from GHCL.
True, GHCL, Sunil Bharati Mittal.
Then Sharif Ahmad.
All that is now reiterated in Sanjay Dutt.
Sanjay Dutt. But probably it would be suffice for me to conclude if I were to make this submission to your lordship.
Well, you don't have judgment? Idya.
Latest is Sanjay Dutt. And for all evidence, I have Namita. Your lordship would put us on a proper track and guide us, my lord, as far as the authorities.
Not Tammanalla, sir.
No, it is in your lordship's fingertips, my lord, they were rejected.
They should be.
He dare not put your lordship
They
on
should
a
be
wrong
ready with
track with
everything.
regard to the law and the point that is involved in the case, be it an offence or be it a procedure. We can't put the court on the wrong track. Certainly, my lord, I am optimistic about it, or very, very.
Adike our homework mind.
Well, my lord, probably if the efforts which I am putting to have the advantage or getting my client a higher relief. But I'm sure your lordship would certainly agree with me that if my lord, in the event of my lord being persuaded to accept my submissions, I took your lordship to the proceeding sheet of the case.
Yes.
But there has been absolutely no proper judicial application of mine.
That will consider.
Not only under section 190, 1B, but also under section 204 of the CRPC. Well, an order of remand simpliciter by setting at naught this order and remitting the matter back to the magistrate for fresh consideration. Probably, my lord, if my lord were to refer to, well, I'm nobody to, my humble request before your lordship is, if my lord were to refer to, look here, these are all the things, CW1, CW2, CW3, CW4, Manoj, and then Aradhya, and then, then my lord,
We'll consider all that kind.
Yes.
Now, both of you have relied on judgments, on facts. We'll see.
Probably that would be an eye-opener. That would be an eye-opener to the trial court to advert to all these evidence or the materials available on record. Well, if he is still, were to say, yes, I'm going to take cognizance and issue process, that is a different issue. If I am agreed, my lord, I'll be again before your lordship. Or if you were to dismiss the complaint, my lord, as the final report, my lord, it is prosecution, if it is agreed, they will be before this court.
Yes.
That would be my respectful submission. My lord, one more submission is this. My lord, there are 3 writ petitions here.
Oh, the other 2 writ petitions.
Yes. The other 2, my lord, I'm sure straight away, my lord, there has been no consideration with regard to the offence under section 204 and 214 at all. He does not even refer to it at all. Simply charge sheet is filed, therefore cognizance is taken and issue summons. For what? Against whom? 204 and 214. Straight away, my lord, I'm very, very optimistic, my lord, it has to go. It has to go. It has to go. There can't be any doubt about that. That's what your lordship hands.
Yes.
My lord, here, probably, my lord, one petition to be disposed of on merits and the other petition cannot be
on cognizance.
On cognizance. Probably, entire matter.
That we'll see.
So that the magistrate could apply his judicial mind, find out whether an offence is made out under 204 or 214 or not, that he has got to do. But the third petition which I filed is for the grant of the relief of anticipatory bail in the case.
Anticipatory bail?
Yes.
ಎಲ್ಲಿದೆ? Oh, 18.1.
Well, the offense that is alleged to have been committed by me, according to the prosecution, is one which is made penal under section 8 and under section 354 capital A. That is all. Earlier, my lord,
Charge sheet ಹಾಕಿದ್ದಾರೆ.
charge sheet ಆಗುವಾಗ 204 and 204, ಅದು less than.
No, insofar as anticipatory bail is concerned, charge sheet is already filed.
ಹೌದು. ಯಾತಕ್ಕೆ ನಾನು why I am before this court seeking for the grant of anticipatory bail after the filing of the charge sheet is, they would go to the magistrate. But now the law laid down by the Supreme Court, commencing from Ranesh Kumar till this day is, where the offense alleged to have been committed in respect of which the sentence that could be imposed is less than 7 years, that he has got to comply with 41 and 41 capital A. Otherwise, even the Supreme Court, my lord, took a serious note in the latest judgment saying that it would amount to contempt.
POCSO.
My lord, the offense is, whether it is POCSO or IPC, whatever it may be, my lord, the sentence that could be imposed, unless and until there is a prohibition under the act, my lord, is 7 years, 3 years. It may extend.
Even 8.
5 years.
8 is 5 years.
5 years. Ashte. 7 is the offense or the misconduct. 7 is made penal under section 8. 8 is 3 years, extending up to 5 years. Then 354A is 3 years. Therefore, he ought to have complied with 41A. He did comply with 41A. He would issue me a notice.
Yes.
I would go. I would appear before him, give my voice sample and all that. On the second day, when I was asked to appear before him on 12th of day, I would request him with a communication addressed to him. I'm sorry, I have got to go to Delhi on some urgent political work. Kindly permit me to appear before you on 17th. Is there anything wrong in it? There is absolutely nothing wrong. What the IO does is to overcome, my lord, the law laid down by the Supreme Court
73 orders.
of inviting the wrath of the court for contempt. He would go, make an application under section 73 before the trial court and ask the trial court to issue a non-bailable warrant against me. It is that that has necessitated me to knock at the doors of this court, seeking for the grant of the relief of anticipatory bail. Well, at the trial, I need not question the legality and correctness of the order passed by the trial court under section 73. The apprehension of arrest is justified because the court has issued a warrant. Apprehension, that is more than sufficient. Therefore, my lord, I have sought for the grant of the relief of anticipatory bail in the third petition.
So then the professor sir is submitted by taking this court to a judgment with regard to anticipatory bail also in a case of POCSO. And I will consider all that.
Yes. My lord, there is no prohibition under the statute.
No, that is not.
My lord, unlike certain statutes, my lord, if I am right, subject to what my lord would say, section 18 of the Atrocities Act,
No, there without.
there is a
hearing-
prohibition.
That is without hearing the complainant.
There is a illi a prohibition, POCSO ಯಾವ prohibition.
So even there I have interpreted that it is not absolute.
My lord,
Because
should
question
be
of
my
liberty of a
full
person.
submission.
Yes.
I'm deeply grateful to your lordship and deeply
Heard.
obliged for all that.
Professor sir, anything, nothing else ಅಲ್ಲ?
ಅಲ್ಲ ಅವರು ಜಸ್ಟ್ ರೈಟ್ಸ್ ಕೇಸ್ ಹೇಳ್ಬಿಟ್ಟು only the special judge has to consider. In fact, that precisely was the argument which was addressed. Where request
Special judge has
yes,
to
kindly
consider what? That bail.
No, consider the question.
Earlier judgment is that of 3
Presumption.
judges, full bench. Later judgment of Pardiwala is a 2 judges bench judgment. That is the
My
2
very
judges bench
respectful
judgment does not refer to 3 judges bench judgment at all.
No. Attorney General's case is also considered. It is interpreted by the 3 judges, by the
That I will consider. You need not worry about that. Yes.
yeah, para 185
Yes.
directly on the question.
Yes. That you have read, I have marked. Sir.
It should be considered at 482. That is the law laid down, which my learned friend did not
I will
refer to
consider
it.
all that.
Yes.
My lord, I am yet to argue the case.
Sir, ನೀವು ಇದ್ದೀರಾ?
204. May I just point out? My learned friend.
My lord, may I pray, my lord, I will come over to Dharwad. Kindly have it on 22nd, my lord, by 2:30.
ನಿಮ್ ಬಿಟ್ಟಿದ್ದು, yes.
By 2:30 on 22nd, my lord.
23rd, sir, not 22nd, 23rd.
Sir,
Please, my lord.
may draw the attention for 204. Since my learned.
ಅದನ್ನು ಹೇಳ್ಬಿಡಿ, sir. Yes.
Yes, kindly permit me to show from 204.
Yes, sir. Please.
There are two events which have attracted this provision. Number one, they manipulated the entry register, which had shown the exact time at which the complainant and the daughter had entered, and Tagdur had entered. Now that is we have the digital data also that it is overwritten. 325 is written as 335. All that information evidence is collected. Now please come to 204.
Offering gift.
There are, yes, 204. 214 is gift. Gift is an admitted fact.
Yes.
So 214 is an admitted fact. 204, on which my learned friend is so heavily relied. Kindly permit me.
Yes.
204.
Yes.
Yes. Whoever secrets or destroys any document or electronic record. Document is the register. Electronic record is the phone, which he may be lawfully compelled to produce as evidence in a court of justice or in any proceeding lawfully held before a public servant as such. Now, so far as the entry register is concerned, it comes under the first clause. See, that is a document. The entry register which has been manipulated to prevent it being used as evidence. Second is important, where the Facebook details were deleted.
Who deletes it?
Deleted by the accused. Deleted by A2, A3, A4 at the direction of A1. That is, or
no, Facebook alli yaar account al delete madi.
It was deleted from the account of the prosecutrix, victim.
How can someone else access the account and delete it?
No, they took the password and did it. All those details, yeah, all those details have come. That they have done it forcibly. They forcibly brought them back from the flat.
That evidence, yes.
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 No, that is fully, he has admitted that fact also, that they went and brought them back to the house of the accused. That is also. So obliterates or renders illegible the whole or any part of such document or electronic record with intention of preventing the same from being produced. Preventing the said Facebook account being used as evidence against the accused.
Yes.
So both the entry register and this, and this is digitally established, that they have done this is digitally established. Therefore, there is no substance in this. Then so much reliance was placed on Aradhya. I would request the court to kindly permit me to ask this. Who is this Aradhya? It is Aradhya by accused number 1 to get any connection, which is also documented. He is man Friday. He is there with him every minute, every day, 24/7. And such a person, he gives a statement. Though a question was asked about something else, he comes to say, repeatedly check madi anta kelidru. That was not at all the question. So, with these submissions, I very respectfully submit that all the sections on which cognizance has been taken, there is enough and more material.
So, no more submissions from
no more. I do not propose to argue.
Yes, Balan sir, you want to submit?
Yes, my lord, by 23rd, your lordship said I will come on 23rd.
Balan may consider this. I have also
yes, argued for you.
Behalf of the complainant,
I guess.
No, yes, argued. That's okay. There are a lot of
for you to
allegations are made against the complainant.
I don't think that.
ಅದು ಹೇಳಾಗಿದೆ ಅವರು.
ಅಲ್ಲ ಅದಕ್ಕೆ judgment ಕೊಟ್ಟಿದ್ದಾನೆ.
It will only delay the proceeding. ನನಗೇನಿಲ್ಲ.
But your lordship proceed to pass orders. Judgment.
Yes. Heard the learned senior counsel sounds all ಅಂತ ಹಾಕ್ಬಿಡಿ. ಹಾಕ್ಬಿಟ್ಟು ನಾನೇ ಬರೀತೀನಿ ಕೊಡಿ. ಅವ್ರಿಗೆ ಮಾಡಿ. Heard the learned senior counsel C. Nagesh appearing for the petitioner, a respondent and Professor Ravi Kumar and Balan appearing for the complainant. Judgment reserved.
Please.
Yes. Interim order subsisting will continue till the pronouncement of the judgment. Yes. ಅದು 23.
Grateful.
There's one more urgent matter, Bangalore.
There,
Mayur.
Revanna matter ಇದೆ.
Sir,
we have
Revanna 23rd man.
A week after next ತಗೊಂಡ್ರು.
ಆಯ್ತು. 30th.
Please. Please. Oblige.
My lords, serial number 20, my lord.
ರೇವಣ್ಣದ್ 30ಕ್ಕೆ ಮಾಡಿ.
ಅದು ಒಂದು ಇಂಟರ್ವ್ಯೂ ಮಾಡೋದಾದ್ರು ಕೊಡ್ಬೇಕಾಗುತ್ತೆ.
ಅದಾದ್ಮೇಲೆ ಕಂಟಿನ್ಯೂ.
ಅಲ್ಲಿ 21st ಇದೆಯಂತೆ ಟ್ರಯಲ್ ಕೋರ್ಟ್ ಅಲ್ಲಿ.
ಅಲ್ಲ ಅದು ಕೊಟ್ಟಿದ್ದೀನಲ್ಲ ಅದರಲ್ಲಿ.
ಇಲ್ಲ ಇವತ್ತು ಮಾಡೋಣ ಹೆಂಗಿದ್ರು 21ಕ್ಕೆ ಇದೆಯಲ್ಲ ಅಂತ ಅಂದ್ಬಿಟ್ಟು.
Then Professor sir.
239 ಕೇಳೋದು ಬೇಡ ಅಷ್ಟೇ, ಇನ್ನೇನಿದೆ ಬಾಕಿದೆಲ್ಲ ನಡೆಸಲಿ.
ಯಾವ 239?
ಅದು ಆರ್ಗ್ಯುಮೆಂಟ್ ಬಿಫೋರ್ ಚಾರ್ಜ್ ಅಂತ.
ಅಲ್ಲ ಅದಕ್ಕೆ
ಆರ್ಗ್ಯುಮೆಂಟ್ಸ್ ಆಗ್ತಾ ಇದೆ.
ಅಪಿಯರ್ ಡೇಟ್ ಇರೋದ 21ಕ್ಕೆ ಆರ್ಗ್ಯುಮೆಂಟ್ ಏನಾಗ್ತದೆ?
ಆರ್ಗ್ಯುಮೆಂಟ್ಸ್ ಮುಗಿಲಿ. ಅದನ್ನ
ಅಲ್ಲ ಲೆಟ್ ಹಿಮ್ ನಾಟ್ ಫ್ರೇಮ್ ದ ಚಾರ್ಜ್.
ಅಲ್ಲ ಅದನ್ನ ತಾವು ಹೇಳಿದಿರಿ.
ಹೇಳಿದಿನ ಲಾಸ್ಟ್ ಟೈಮ್ ಹೇಳಿದಿನ ಅದನ್ನ.
ಹೌದು.
I have said let him not frame the charge ಅಂತ ಹೇಳಿದೀನಿ.
And the accused appeared and created a drama there.
ನಾಗೇಂದ್ರ ಕೇಸ್ನಲ್ಲಿ
ಪ್ರಜ್ವಲ್ ರೇವಣ್ಣ ಕೇಸ್ ಇಲ್ಲ ಹೇಳಿದೀನಿ.
Not in this.
No, let the arguments go on. Hearing before charge agli. Let him not frame the charge. That's all. The learned senior counsel submits that the matter is at the stage of hearing before charge and the hearing is on. The hearing is on. The concerned court is permitted to hear the matter on at the stage of arguments or hearing before charge, but shall not frame the charge till the 30th of January 2025. Yes.
Please.
Kindly pardon me if I have tried my lord's patience, my lord.
ಅದೆಲ್ಲ ಏನಿಲ್ಲ. ಅದೇ ಅಂತಂದ್ರೆ.
My lords, serial number 20, my lords, pertaining to Bangalore bench.
Wait, sir. ಅದೆಲ್ಲ 23rd. Except this 20 ಯಾವ್ದಿದು?
Serial number 20, my lords, landlord tenant dispute, my lords.
All right. On 23rd, interim orders will continue except this Mayur. Santosh Hospital. Jagdish sir.
Also said pointed out one judgment on the previous
day. 23rd urgent ಆಗಿದೆಯಪ್ಪ.
This is Srishananda's order. Number 70.
Takes away the right FSL, private laboratory. You could have come online. Why did you come?
Not online.
Truth Labs ಕೊಟ್ಟಿದ್ದೆ. Yes.
This is Santosh. Adana Truth Labs. Yes.
ಇದು Truth Labs ಕೊಟ್ಟಿದ್ದೆ. ಇದು ಸಂತೋಷ್. Yes, Jagdish is there. We'll do a role reversal. 23rd you appear online. He will be here.
I may just make one.
Interim order ಕೊಟ್ಟಿದ್ದೀನಲ್ಲ.
But I completely get that. But what has happened is 60 other people. There are 60 other accused persons on the same point.
ಎಲ್ಲಿದೆ?
My lords, we have not filed, we have not preferred any petition, my lords, because I did not want to burden this, your lords.
File, sir. But ಅಲ್ಲಿ ಹೋಗುತ್ತದೆ.
That's the reason, my lords. ಇಲ್ಲಿ order pass ಆದರೆ ನಾನು ಇಲ್ಲೇ file ಮಾಡಿಸ್ತೀನಿ.
ಅಲ್ಲ ಇಲ್ಲಿ order pass ಆದ್ರೆ ಬರುತ್ತೆ, but otherwise it goes there.
Yes, my lords. That is the.
Then there should not be conflict of orders.
Yes.
23rd will pass some order. Now I have granted you interim order.
Yes.
I'll dictate it on that date, sir.
The only point which is for consideration. But your lordships as well as Justice Vishwajit Shetty have already clarified this point. Well, foreign offense under 27A and B, but is found to be consuming. That is 6 months to 1 year. Well, either you can say that there are eyewitnesses to say that he's consuming drugs, but does it go to the effect of proving that he had consumed drugs? Not the only aspect that will come into the favor of the prosecution at that point in time is a medical report.
Yes.
Whether that medical report is as per the law as on date. That's the only question we have asked. Because my lords, I'm not going on the facts of the case. I'm not going on.
No, legally, facts sodre then it requires
Exactly.
evidence.
Exactly. So I'm just relying on
TPS
that.
cases 482 ಯಾವ್ಯಾವ touch ಮಾಡಿದ್ದಾರೆ.
Yes, my
None
lords.
of them are on the facts of the
It's
case.
only the technical aspect
It's
of it.
only on legal principles.
Yes.
Facts of the case, if you go, it is a matter of trial.
Yes, my lords. Yes, my lords.
So we'll take this on 23rd and finish it on that.
Yes, my lords.
Once this, one I will decide ಮಾಡಿದ್ದೀನಲ್ಲ Gopal Reddy's case.
Not Gopal Reddy. Yes, ma'am.
No, so every crime should come here only if all
I'll
the
file the
accused-
rest, my lords. Lord, the reason why I did not prefer the set of batches is because, my lord, one person who is the accused number 10, if I'm not wrong, has already approached the court during vacation, Hema Kolla. My lord, she has secured a interim order during vacation, my lord, through Justice Hemant Chandangad. My lord, the grounds on which they are relying and the ground on which I am relying is absolutely different, my lords.
Oh, then don't take that risk.
Exactly, my lords. And the other aspect also which comes in, my lord, I admit,
No, accused number 5 ಅಲ್ವಾ ಅದು?
my lord, Gopal Reddy is accused number 5.
No. The other.
Hema Kolla is accused number 10.
All right.
My lord, and there is one more aspect in that. I had made a submission with your lordships that KC General had conducted medical test. Lord, to prove my point there, my lord, it is only in respect of Hema Kolla that they have filed this KC General Hospital report.
Oh, nothing, nobody else.
Nobody else.
So there is no examination at all.
Absolutely. And even in her case, my lord, even if you were to consider that, whether KC General is a laboratory or an hospital that can consider it, not is yet again a question.
Anyway, you have filed the same thing. Have you filed?
I am not.
No. We'll answer this.
Grateful.
Amel, all the others you can.
Grateful.
23rd, heard the learned counsel Mayurudi Banu appearing for the petitioner. Awaiting the submissions of the learned additional SPP, list the matter. And 23rd, he is coming for many matters.
I'll be here.
23rd, only Bangalore bench matter.
I'll be here.
Come, list on 23rd.
Grateful.
Not at 2:30, regular time.
I'll be here.
Yes. Madhukar,
But I pay for the petition.
ಇದು 23ಕ್ಕೆ ಹಾಕ್ತೀನಿ, ಅವತ್ತು ಮುಗಿಸೋಣ. ಮಧುಕರ್ ದೇಶಪಾಂಡೆ is not there.
Please, ma'am.
Stay ಕೊಟ್ಟಿದ್ದೀನಲ್ಲ ಸರ್.
Yes, madam. Stay is there.
Interim ಮಿಕ್ಕಿದೆಲ್ಲ list on 23rd. All matters where interim order is there, continue. ಪಾಸ್ ಓವರ್ ಇದೆ ಮೇಡಮ್ ಇಲ್ಲಿದು. ಸರಿ. ಅದು ಬಂತ?